Right.
Pick up where we left here.
I like that.
Can you vote me yes?
Yes, sir. Mr. Chair, you have a quorum.
And you mark me as a yes. I can't vote, that's the problem. A couple announcements. First, about virtual participation policy. Virtual participation is welcome in the legislative process. To ensure that the process runs as smoothly as possible, virtual participants must sign up to speak 1/2 hour before the committee meeting begins. Of course, this begins next week. Virtual participation is only possible on bills that will be heard in the full committee. Subcommittees will not be taking virtual comments. Participants must be Virginians or recognized subject matter experts. All participants must state who they are, what jurisdiction they reside in, and whether they are representing a group before they present their comments. A presenter on the virtual platform must have the camera on and be physically present in the virtual space. The chair will announce at the beginning of the public comment period how much time will be allotted to each speaker. We just want there to be some common thread about virtual comments from this point forward. Second announcement, we've been working really hard to get people appointed to the State Corporation Commission. I anticipate that we will have a special meeting tomorrow with the House Committee on Commerce and Labor and our Labor and Commerce, and I would hope at that time that we will be able to certify 2 people to the State Corporation Commission and elect them on Wednesday with the rest of the judicial elections. That's my aspiration, and I think that can happen. Certainly that's not a guarantee, but that's the plan. Third, there are some bills that are going to go by today, primarily at the request of the patron. Senate Bill 256, Senate Bill 373, Senate Bill 374, Senate Bill 381, Senate Bill 494, Senate Bill 553, and Senate Bill 118. Do I have a motion to do that? Second. Okay, a motion and a second for those bills to go by for the day. All in favor, say aye.
Aye.
Okay, the bills will go by for the day. The last thing is, last week we only had 3 bills. They were big bills, and we pretty much allowed unlimited conversation so we could get through, we could be fair to everybody. This meeting will be more like a regular committee meeting. I hope we get through a whole lot more than 3 bills. If we're stuck at 3 by the end of this session, then I will have to be deposed as chair. Because I don't have the electronic sheet, I don't have the sign-up sheet in front of me. So, Hobie, I would...
Mr. Chair, parliamentary inquiry.
Senator Obenshain.
Mr. Chairman, did you say that we are going to have interviews for State Corporation Commission tomorrow or Wednesday?
We'll have interviews, and I hope we can certify them, yes.
Mr. Chairman...
we'll have interviews on tomorrow, yes.
Mr. Chairman, can you let us know today who's going to be interviewed tomorrow?
I hope that's the plan, Senator Obenshain, but right now I just don't know what those names are.
Mr. Chairman, would it be the anticipation that we would be given at least 24 hours notice?
The anticipation is that you would know by this evening at supper time, and we will have the interviews tomorrow after the session.
Thank you.
Okay, Senator Boysko is first on the list. Senator Boysko, what's your bill?
Thank you, Mr. Chair. 6, health insurance limit on cost-sharing payments under prescription drug under certain plans.
Okay. Senate Bill 376. Turn your attention to Senator Boysko.
Thank you, Mr. Chair. As many of you know, if you have a chronic condition like MS, leukemia, hemophilia, or countless others, picking the right health insurance policy to meet your medical needs while also keeping affordability in mind can be challenging. Not only can it be confusing to know which policy to choose, but the cost-sharing structure for prescription medications needed to treat these conditions, which is chosen and implemented by the health insurance companies, can impose financial burden that many people simply cannot overcome. More specifically, one of the largest financial burdens for patients is when their prescription medication is placed in a cost tier with co-insurance or a percentage cost, which can be very unpredictable, as opposed to a cost tier with a copay or a flat predictable dollar amount. Like several other states that have passed legislation Virginia can now offer these patients a new choice that can help them. SB 376 would require that 50% of plans offered in the small group and the Virginia Health Benefit Exchange insurance market would have copay as the only plan structure. It would also require that monthly out-of-pocket costs for prescription medications are capped at $150 per medication per month. This legislation is designed so that patients can choose a plan that best suits their medical and financial needs, and it simply gives the patients a choice, not requiring that they pick this kind of plan or that all plans offer this design. We are very lucky to have incredible medical breakthroughs, but we have to make sure that Virginians can afford access to them, and this bill has tremendous support from the patient advocacy community, many of whom are here today to let you know that we appreciate your consideration of the bill. That's correct.
Mr. Chair. Mr. Chair, Senator Boysko, who pays the cost after $150?
The insurance company does, Mr. Chair. I believe the insurance company pays that.
Mr. Chair, follow-up question. Senator Boysko, if the insurance company is going to pay for it, then ultimately that extra money that's going to have to go out on that is going to be shared across all the insureds in the plan. Is that the idea?
Mr. Chair, Lauren Edwards is here with the Government Affairs for the Leukemia and Lymphoma Society. She might want to answer some of these technical questions. I am not a underwriter for an insurance company.
Yes, sir, Mr. Chair and members of the committee. My name is Lauren Edwards. I do government affairs for the Leukemia and Lymphoma Society. Thank you. So to answer your question, this bill does not change the total maximum out-of-pocket costs that a patient pays over the course of the year. This simply splits that total cost over the course of a year instead of a patient paying that whole several $1,000s right up front the first month of the plan. So the patient ultimately still pays the same maximum out-of-pocket costs. It just splits that over the 12 months of the plan rather than right up front.
Mr. Chair, I'm pretty slow at math, I think. But if it's, ma'am, if it's $150, that's it, 30 days, and it's the same, I don't know, my father takes a pill that's a month, $750 a month. So if he's capped at $150 for 12 months, what happens after the 12 months?
So the plan then restarts. Every plan restarts at the beginning of the year. That doesn't change as according to this bill.
Or Mr. Chair. So then what happens to the rest of the money if it's $750 and we're paying $150? Doesn't that add up? Who pays for that?
So the insurance company will help disperse, they'll pay for the rest of that throughout the course of the year. So essentially once a patient hits a maximum out-of-pocket cost or, maximum out-of-pocket limit set by the federal government, the plan then would pay 100% of all of their costs after that. So eventually the plan will be paying 100% of the costs. This just helps to spread that out over the year.
Mr. Chair, last question.
Senator Reeves.
So wouldn't that mean that the policyholders, the plan itself, the group, whatever you want to call it, is overall premiums are going to go up to help pay to offset those costs? Is that correct?
Mr. Chair and Senator Reeves, no, sir. According to our actuarial analyses and data from other states that have implemented these plans, this plan choice, and the actuarial analyses have not shown any increased premiums because the total spending still stays the same.
Tom, could you tell us is this implicated by the HERC statute or the authority for HERC?
Mr. Chair, Senator Boysko, yes. Under the Health Insurance Reform Commission, that statute requires any measure containing a mandated health insurance benefit or provider that is proposed to be sent there, and then under our mandated health insurance benefit definition, we include anything that places limitations or restrictions on deductibles, coinsurance, copayments, et cetera.
So is that implicated by the language in this bill?
So, yes, sir, this would fall under that definition.
So this will have to go to HERC. You prepared for that?
Mr. Chair, that was my expectation.
Okay, well then, if there's anybody else that wants to speak to it, I hope you understand, the HERC process we've got is a 24-month process to look at, to develop or to see what the mandate, what the cost is going to be, so as not to unnecessarily raise health insurance. Does anybody want to speak for or against this? If not, I would appreciate it if somebody would make a motion to carry this bill over and refer it to the HERC Commission.
So moved, Mr. Chairman.
Okay, got a motion and a second to carry the bill over and refer it to the HERC Commission. Please, do we need to open the roll on this? Okay. Hobie, you'll need to vote for me still. That's not a word. Easy.
Ayes 15, no zero.
Okay, thank you. You've got a couple more bills. One more bill?
Yes, sir. Senator, Mr. Chairman, SB 370 deals with wage salary history.
Okay, SB 370, okay. Okay, Senator.
Thank you. Chairman Deeds, this is a bill that you have heard many, many times and has passed through this body a number of times in a similar form. Senate Bill 370 addresses the practice of employers who are seeking salary history of prospective employees, and this bill requires adding a pay range with any job posting to make it clear what the salary range is. Virginia's Equal Pay Act, which was passed into law 50 years ago this year, mandates that employers must compensate their employees equally for equal work, thereby empowering employees to pursue legal action against discriminatory wage practices. Yet it's clear that we still need to update the law to address the persistent wage disparity impacting women and minorities in Virginia. Women in Virginia, on average, earn 80 cents for every dollar paid to their male counterpart, with the gap widening even further for Black and Latino women. We here in the Senate of Virginia have passed updates to this law in the past 2 legislative sessions where it died in the House of Delegates. SB 370 aims to narrow the wage gap with a clear, simple directive for employers, prohibiting seeking and relying on a wage or salary history of the prospective employee. The employers will also be required to disclose the wage salary range for the position in each public and internal posting for each job, promotion, transfer, or other employment opportunity. The benefits of narrowing the wage gap are huge. On average, women employed in the United States lose a combined total of nearly $1.6 trillion every year due to the wage gap. These lost wages mean women and their families have less money to support themselves, care for their families and communities, and save and invest for the future. Families, businesses, and the economy suffers as a result. Closing the gender wage gap would reduce poverty in families with a working woman by half. In the United States, mothers are the breadwinners in 40% of families with children under 18 each year, and about 70% will be the primary earner at some point in their life in the first 18 years of motherhood. You will remember this is the 8th time I have introduced this legislation before the General Assembly to narrow the wage gap. We have passed it through the Senate several times, and I will persist until this legislation passes through both chambers and lands on the governor's desk. Not acting on these bills places families in poverty, and forces the workers to have 2 and 3 jobs, to work longer and harder for less money than others earn, despite having the same qualifications as their coworkers. By prohibiting the practice of setting wages based on prior salary history and providing a wage salary range with a job posting, we can begin to dismantle the systemic barriers that perpetuates wage inequality. This change is crucial in preventing and perpetuating the historical wage inequalities from one job to the next, particularly affecting women and people of color. I am grateful for the collaboration of the Women's Law Center, who has been with me through this entire process over the past 8 years. Dai Hai Kim is here to speak in support and to answer any technical questions, and I thank you for your time and consideration.
Thank you, Senator. This is a bill we passed out of this committee on a party line vote last year, and it got over to the House and was tabled, I think. And if we're going to pass it out of here today, it's going to have to go to Finance. So first, I'll ask if anybody's got any questions of the sponsor.
Mr. Chairman,
Senator McDougal.
just reading in section G, it looks like if there is an alleged violation, the commissioner makes the determination of what information to receive in reference to that and then makes the decision. Is there any, and it does not appear that there's any appellate process. Is that accurate?
Mr. Chair, I would say that there's already a right of action in the Equal Pay Act in Virginia.
Mr. Chairman,
Senator McDougal.
I guess section G is about a violation of this provision, so this new act. So if a small business doesn't set the salary range that somebody decides in good faith, that they appeal it, well, and it looks like just the commissioner makes a decision, and that decision is not appealable to anywhere. Doesn't say what determinations the commissioner has to make in order to determine if it's.
Mr. Chair, I would say that the commissioner does have the power to administer, carry out, and enforce the provisions of the section, just like he does in other areas under his purview. And I would.
Just seems like if you're having a penalty, then you should be able to appeal it to a court.
Mr. Chair, I would just make the commissioner has the right to take complaints in a variety of things around employment, and I would say that
Mr. Chairman.
perhaps the clerk would like to clarify if there is a hole in this.
There may be another code section that allows them to file suit or something if they're found in violation, they're aggrieved.
Mr. Chair, Senator McDougal, Senator Boysko, it's an administrative decision by the commissioner. I'm not all that familiar with the Administrative Process Act, but I believe those things are built into that, which is under 2.2, Title 2.2, the APA. Senator McDougal, I'm sorry.
Mr. Chairman, I'm not my area of expertise, but when we say that it would go under that process, because this just says informal hearing, commissioner decides. I don't know what an informal hearing is.
Yeah, and I'd have to double check the APA, but yes, sir, it could be more clear that it would be appealable under that chapter under Title 2.2.
Tom, is this the language from the bill that was introduced last year?
Yes, sir.
Senator McDougal, do you have an amendment, or do you want to take it back and try to prepare an amendment? Okay. Okay.
Mr. Chair.
Well, Senator Peake.
Yeah, just a question of either counsel or the patron. All right, I run a law firm. My law firm needs an attorney. I look up on the state website to see how much we're paying, or the city website, how much we're paying Commonwealth's attorneys or public defenders, which is public knowledge. I go look for that information, or I ask somebody who worked at those offices, how much do y'all make there? And then I offer an attorney more money based on that. Have I violated this act?
Mr. Chair, the requirement to set forth would be that there would be a salary range that would be posted publicly in all job openings. And I would just to follow back up, there is already a private right of action. Anybody who feels that they are being subject to discrimination on wage equal pay has the right to hire their own attorney and go. This would provide some guardrails for what employers need to do so that they are complying with the law that has been in place for 50 years. The commissioner has we're giving the commissioner a great deal of leeway in deciding how to handle cases that come before them, which I think is more protective of the businesses because they understand exactly what they need to do, as opposed to just saying you have to pay everybody equally, and then anybody can accuse their employer of not paying them equally. This gives you some guardrails so that if you do have a posted wage range, and you're not asking them for their salary history when you are making the job offer and determining their salary, that gives the employer more protection than anybody, I would say.
Mr. Chair, counsel, or again, I'm not posting this. I go into court, I have a case with the Commonwealth's attorney who does a great job. Maybe I'd like to have that person in my office. And then I make inquiries to find out what they're paying at that office. I'm not listing this job. I don't want 30 applications. I see somebody I think is good. I find out how much they're being paid, and then I make an offer 25% more. I am subject to, I violated this. Why not?
Mr. Chair, Senator Peake, this job is dealing with publicly posted job openings. So his question would not apply to, his situation would not apply.
Mr. Chairman, to respond to Senator McDougall's question, and Tom might be able to help us out, but I believe the language would be any person aggrieved by a decision of the commissioner to issue, for the imposition of fines or other actions by the commissioner may seek and review such action in accordance with Article 5 of 2.2-4025 et al. Of the Administrative Process Act and the Circuit Court of the City of Richmond. Further appeals may also be in accordance with Article 5 of the Administrative Process Act. And move that amendment.
So
good luck, Tom.
Okay, you understand the amendment? He was trying to address the problem that McDougall identified. Second. Yeah. So motion and a second for that amendment. All in favor say aye. Any opposed? Okay, the bill's amended. You've got a witness. I'd ask you to be brief if you can.
Sorry, you get to speak.
All right. Good afternoon, Chair Deeds and members of the committee. My name is Dahe Kim, and I am with the National Women's Law Center. This bill contains proactive measures to help insulate Virginia's businesses against gender and racial wage gaps inadvertently arising in their workforce, and thus decrease businesses' exposure to equal pay lawsuits. 18 states and D.C. recently have passed laws addressing a salary history, and research is already showing that these laws are helping to close gender and racial wage gaps. A growing number of businesses have been announcing that they will no longer rely on salary history and are supporting this type of legislation. We are also seeing laws requiring employers to include pay ranges and job announcements take off across the country, not just because transparency is shown to help close wage gaps, but in large part because employers and lawmakers are seeing how sharing pay ranges helps businesses attract and retain talent and save time and costs in the hiring process. SHRM found that 70% of organizations that list pay ranges on job postings say that doing so has led to more people applying to their company. And nearly 2/3 say that doing so has increased the quality of their applicants. And we've heard from small businesses without an HR team that pay range transparency gives them an edge in hiring. But still too few businesses are sharing pay ranges. Currently, 10 states plus D.C. now require transparency about pay ranges. We all want to feel confident that we are being paid fairly, and these two simple measures will go a long way in helping Virginia businesses stay competitive and workers feel confident that they're being paid fairly. Thank you for consideration, and I'm happy to answer any questions you have.
Okay, thank you, man. Are there other people who want to speak to this bill? Senator Obenshain's got a question while we're waiting on somebody else to come up.
Senator Boysko, on lines 31 and 32, failure, no employer shall fail or refuse to disclose in each public or internal posting for each job the wage, salary, or salary range for the position. So if I post, for example, in Lawyers Weekly that we have an associate position open, salaries commensurate with experience, does that put me in violation of this provision?
Mr.
Would seem
Chair,
it would.
Senator Obenshain, I would think that you would need to put an actual figure or range of figures. That would be a reasonable expectation. You have these people who are on your staff already, and you know how much they make.
So further question,
Senator Obenshain.
So if I were to put in that ad that that salary is commensurate with experience, and the range is $50,000 to $250,000, does that comply?
Mr. Chair, I think that, Mr. Chair, Senator Obenshain, I mean, if it's in good faith, and that actually is the possibility of what the
Thank you.
costs were. Yeah, Mr. Chair, there is a good faith clause in here. So if it was done in good faith, yes.
Okay, there was somebody over here that wanted to talk. Come on up.
Hi, my name is Dr. Emily Yen. I'm from the Virginia Education Association. VEA strongly supports this bill. I think one thing that I do want to explain is the importance of this bill. The current Virginia Equal Pay Act mirrors the federal Equal Pay Act of 1963. And one of the key problems of this act and one of the weaknesses is that there's a catch-all category. So when there is a differential between a male and a female employee, and the lower paid employee there's a very narrow exception of when they can file a suit if they have an identical job and if they have an identical job. And so then once the suit is filed, the employer has an opportunity to give literally any legitimate non-discriminatory reason. And that is a catch-all category, and there's a bunch of case law showing that that can be on a really broad range of reasons. And one of the key reasons that many courts have found is that is salary history. And different circuit courts have ruled differently on this particular issue. And it's very important to think about the importance of salary history. I mean, salary history is often a reflection of past discrimination. One of the reasons why we have this lingering wage gap is because of never being able to catch up because of constantly having to report your salary history when changing employers, which is often the mechanism where most people increase their salary to the largest jump. And by removing this salary history, you're removing this past discrimination, which, even though we're looking at the Equal Pay Act, prohibiting this practice will actually significantly reduce the amount of racial discrimination on salary when you look at the racial wage gap. And so I think that it's very important to think about not just this issue of posting, but thinking about what, by keeping this, allowing past racial and gender discrimination to be the basis of future discrimination, what that is going to do. And by enacting Senator Boysko's bill, this bill will close this mechanism, which will be very, very important to achieving both gender equity, pay equity, as well as racial pay equity.
To
Move to report and refer.
Is there anybody in opposition to this? Okay, well, you had a motion down here?
Yeah, move to report and refer.
Second. A motion it's been seconded. Are there other motions? Is there any discussion? If not, open the roll. Two noes.
Ayes 9, noes 6.
Ayes 9, noes 6. The bill goes to finance.
Thank you, Mr. Chair.
Okay. Next on the list is Senator Favola.
Good afternoon, Mr. Chair. I have a few bills before the committee.
Which one do you want passed?
I want 4 passed, and 1 I'm going to carry over. So Senate Bill 87, I would like to carry it over to next week, or pass it by for the week.
Buy for the day, 87?
Senate Bill 87
Okay.
is the one we
Got a motion and a second to pass 87 by for the week. All in favor, say aye.
Aye.
Okay. 87's by for the week. We might not meet again.
Can I draw the committee's attention to Senate Bill 91?
Session Bill 91.
Okay, Mr. Chairman, what this does is it would provide sick leave for agency-directed home care workers. This parallels the bill that we passed 2 years ago, which provided sick leave for consumer-directed home care workers. I think it's a necessary bill. I think it helps ensure quality of care in the home setting. And that's the bill. I can go on in
Okay.
detail. It will have to go to finance.
You think that it will have to go to finance if it comes out of this committee? This is a bill we took up 2 years ago, not last year.
Yes, I said 2 years ago.
Okay. Are there questions for Senator Favola? Are there those in the audience who would like to speak in favor of this bill? I'll give you a minute apiece.
I'm Kim Bobo, Director of the Virginia Interfaith Center for Public Policy. We support this bill and really appreciate the senator's work on this. Thank you.
Okay, thank you, ma'am. Are there others? Are there those who would like to speak against this bill? Okay, what's the pleasure of the committee?
Mr. Chairman, can I just ask one
Senator
question?
McDougal's got a question. We've got a motion to report and refer to finance. It's been seconded, but Senator McDougal has a question.
Of the home health workers, what percentage of them are consumer-directed versus agency-directed? How many
I don't know the
individuals?
exact percentage, but most are agency-directed, most, which would mean a family member would call a home care agency and ask for a home care worker. Consumer-directed would mean a family member would, on their own, find a home care worker. So the agency-directed there'd be a higher percentage of agency-directed home care workers.
So agency director, both public and private sector agencies?
Yes, sir.
Okay. Okay, are there additional questions? We've got a motion to report and re-refer to finance. Unless there's further discussion, open the roll.
Mm-hmm.
Ayes 9, noes 6.
Okay, Senator Favola, you got one. You want to keep taking your chances?
Well, we're going to keep that momentum going. How about Senate Bill 98?
Senate Bill 98, turn your attention to Senator Favola.
Health insurance prior authorization, and I would ask the committee to adopt an amendment.
Do we have an amendment prepared by the staff?
Yes, sir. It's lines.
It's a line amendment?
There would be a whole new number 5, and
We've got a substitute then. Okay. Is there a second to that motion? All in favor of adopting the substitute, say aye. Okay. Any opposed? The substitute is properly before the committee. Turn your attention to Senator Favola.
Okay, thank you. So what this does is it requires that if a prior authorization for a drug request is approved and services or supplies have been provided, the carrier shall not revoke, limit, or modify that prior authorization unless there's evidence that the authorization was obtained on a fraudulent basis. And final actions by the FDA or other regulatory agencies or the manufacturer removes the drug from the market. That would be a reason for revoking the authorization. And then we've got small 3, if a combination of drugs prescribed would cause a drug interaction and for a generic or biosimilar is added to the drug formulary. This is a patient protection bill. This is ensuring that once a drug is authorized, it's not revoked unless there's some substantial reasons. And when you have patients who are terminally ill, for example, and they need to get a drug right away, this bill will help. I am carrying this on behalf of the Medical Society of Virginia, so Scott Johnson or others may have a comment.
Scott, primarily tell us what the difference is between the old 5 and the new 5.
Yes, sir, Mr. Chairman. Scott Johnson, on behalf of the Medical Society. We worked with Anthem and the health plans on the new 5 to clarify certain times that continuation of the drug should not occur. For example, if the FDA pulled the drug off the market, it shouldn't happen. For example, if you had 2 drugs you were given and they are in conflict with each other, it shouldn't continue. So we put some more safeguards in there and spelled that out. So it made it a better paragraph 5. And then on the second amendment on paragraph 7 basically says when you switch health plans, you're going to continue your drugs for 90 days because most of them are a 90-day supply. But again, if you have situations that are addressed in paragraph 5, like the FDA pulls the drug or if it's conflict, you wouldn't have to comply with it. So I want to thank our friends in the healthcare community for working with us. It is a patient safety bill. We don't have situations here in Virginia, but other states have taken this step, and we want to make sure we're prepared.
Okay, thank you. Mr. Gray, is that the truth to the best of your knowledge and belief?
Yes, it's a good description. I would describe the bill a little bit more accurately to say there's 2 parts to it. The first part was a concern about revoking a prior auth, which frankly doesn't happen very often. We haven't found many good examples of. The second part is about 90 days when you switch plans. The plans were not uniformly excited about 90 days. Some were okay, some were not. But all of them had the concerns that got reflected in the amendment. And so we're thankful for the efforts to work with us on the amendment. But the status is some aren't happy about it.
But you love it.
I am happy about the Medical Society working with us on the amendment, and I commend them for doing so.
Well, thank you. Does anybody have any questions for Senator Favola, Mr. Johnson, or Mr. Gray? Senator Morrison.
Thank you. Doug, question for you. Would the I know that a lot of medications are written for 90 days, but would this help somebody in their transference from one policy to another who may not be able to get to a doctor in the new plan within 30 days to have their prescription redone? So the 90 days would give them plenty of time to connect with the new carrier and get the authorization for continuation on that medication. Is that what that 30 to 90 is all about?
It's certainly possible that it would help with that. You don't always switch providers when you switch plans, but sometimes you can.
Okay, thank you.
Thank you, sir. Yes, sir.
Mr. Chair, members of the committee, Brent Rawlings, Virginia Hospital and Healthcare Association, just wanted to say we support the legislation and appreciate all the work that went into it. Thank you.
Thank you, sir.
Mr. Chairman.
Senator McPike.
Thank you, Mr. Chairman. I had a question for either Mr. Johnson or Mr. Gray. Just lines 43 through 45. I know we've considered many bills over the years in terms of, for instance, psychotropic drugs, where if I read this, it says that if I have drop plans or I get drop plans for whatever reason, I've got a gap in coverage, and I've gone through a step process to figure out what works for me. This says that I'm not guaranteed to go back to where I was, but to go back through a generic process. Can you speak to that, Doug or Scott? I just want to make sure we're not unraveling some other work we've done in prior years, and can you point to where in the legislation that I am mistaken?
Mr. Chairman and Senator Pike, this does not affect the section that we worked on previously. I think it was 2 years ago, and it was a collaboration between the 3 of us on your legislation. It doesn't affect it.
Does that answer your question? Okay. Are there people that want to speak in opposition to this compromise legislation? A motion is second. Are there other motions? Is further discussion? If not, open the roll.
Ayes 15, no 0.
Okay, Senator Favola, you're on a roll.
I'm on a roll. I'm going to go a little bit out of my sequence here and ask the committee to turn their attention to Senate Bill 425, because my last bill, I think, will probably have a more robust discussion. So on Senate Bill 425, we call it the Health Insurance Ethics and Fairness and Carrier Business Practices. And this This is the result of a bill I carried last year, which passed the General Assembly, and it established a work group, and the Bureau of Insurance brought together stakeholders to really specify the process between providers and insurance companies. So what this bill does is it requires additional documentation, and when that documentation substantiating a claim, if you will, is provided, it has to be provided electronically. We define what a clean claim is, so it's understandable by both the doctors.
Mr. Chairman, do we have a substitute?
Oh, excuse me. Yep, there is a substitute. Aye. Thank you, Madam Chair, Mr. Chair. I'm sorry about that. And then we establish a reasonable and consistent time limit for a retroactive denial of claims. We require the carriers to make available to providers whether a member's health plan is fully insured or self-insured. We make explicit that payment timeliness requirements are important, and we require that carriers and providers confer and compare their respective data. This is just sort of how you should do business. And we feel that we have to articulate this in statute. It's really important to providers. I would hope it would be very important to those who are paying medical claims. And it is a consensus bill, once again. So. Yes, it should be identical. I don't know if the House bill...
So, and my understanding was there was peace in the valley on that bill, so...
Yes.
Okay.
That you're correct.
Okay. Mr. Gray, this is something you've been involved in? Peace in the Valley.
Mr. Chairman?
Senator Evans got a question. He wants to serve that piece.
Just on the retroactive denial piece, is there a limit now on retroactive denials? It's on line 149 of the substitute. Is that something that exists today?
Mr. Chair, members of the committee, Brent Rawlings, Virginia Hospital and Healthcare Association. And I will allow Mr. Gray to correct me, but my understanding is the retroactive denial period runs with consistent with the time period for submission of claims as the law currently operates. So there's not a specific timeline specified in the law. That's dependent upon provider contract. And the change that was here was at the request of the plans in terms of how the Bureau of Insurance interprets that. This just conforms it to the way that the Bureau is interpreted going forward. So it's not changing the retroactivity period.
Thank you, Mr. Chair.
Okay. There was a motion to report. Is there a second?
Second.
Okay. Is there any further, and I apologize, is there anybody else that needs to object to this bill? Okay, we've got a motion to report and a that's been properly seconded. Open the roll, please.
Ayes 15, no 0.
Okay,
My last
Senator
bill.
Favola, you're on a roll, but you might be pushing your luck.
Well, let's see. My last bill, Senate Bill 174, and there are some line amendments. So I would ask that the amendments be adopted.
Okay, the bill's amendments, have the amendments been distributed? Okay. The amendment, there's been motion, and these are technical amendments, is that correct?
Yes, sir.
Okay. The amendments have been moved and seconded. All in favor, say aye.
Aye.
Okay, any opposed? Okay, the bill's been amended. Okay, please present your bill.
Okay, Mr. Chairman and members of the committee, what this bill is intended to do is provide a framework for financial institutions to take action if they feel it's appropriate. There's not a mandate in here, but for financial institutions to take action to protect abuse of financial record, to protect somebody's bank accounts. Frequently, it could be an elderly person, but not necessarily. certainly a vulnerable person. And so it lays out steps like a financial institution or their staff may have reasonable cause to suspect that a vulnerable adult is a victim or a target of financial exploitation. They may convey the suspicion to one or more of the following. A person who has been listed by the vulnerable individual has a trusted contact, a co-owner or additional authorized signee, any person known by the financial institution to be a family member, including a parent, adult, child, or sibling, or an agent under a valid power of attorney. This is something that has come, versions of this bill have come before our committee for the past several years. It is something that individual consumers want a framework for, banks want a framework for. This reaches a happy medium. There's certainly cases where I think individuals would want banks to do more, yet we have to balance privacy and a number of other issues when you're dealing with somebody's personal financial records. I think this is the best we can get with a complicated situation, and we did the best we could, speaking with many stakeholders and others. I do hope it is the wish of the committee to pass this bill.
Mr. Chairman.
Senator Obenshain.
So, Mr. Chairman, how does the bank know that the person who's designated isn't the exploiter?
Well, that's an excellent question. I will let Mr. Brunning answer that, but they would have some safeguards in place.
Mr. Chairman, members of the committee, Matt Bruning with the Virginia Bankers Association. Senator Obenshain, your question, I believe it's in the bill already that if the person that they suspect is doing the abusing is the trusted contact or a family member, they do not do that. So I mean,
Mr. Chairman,
Senator Obenshain.
Matt, that misses my point. I mean, it typically may not be the person that the bank suspects, but it may be the person who is using their closeness, their proximity, or their relationship to isolate or exploit the elder, and having access to those financial records, I guess, could potentially enable them. I mean, I think most situations is fine, and it may protect some, but I worry about exposing others to exploitation just by having the exploiter getting access.
And Mr. Chairman, Senator Obenshain, I would say that, again, this is permissive, so I think if the bank or the financial institution, the staff didn't know who they think it might be, if there was any doubt, they don't have to do this. They still have the ability to report volitionally to Adult Protective Services, to law enforcement on that, if they want to be safe. This, again, if they think it's, Senator Stanley is the one that's doing it, they're not going to, they may not go ahead and reach out to anybody except for APS and law enforcement.
Senator Rouse has a question. If you're completed, Senator Obenshain. Senator Rouse.
Thank you, Mr. Chair. Question, I guess, for the banking expert here. Can you speak to the thought or the status of power of attorney and how that relates to a bank, a person who has power of attorney over someone they're taking care of? Maybe it's an elderly person, maybe disabled, maybe a young adult. The person has power of attorney to take care of an individual and provide all their life necessities. How would a bank determine if that person is being exploited or something?
Mr. Chairman, Senator Rouse, I think usually, especially in the context of financial transactions with a power of attorney, that is listed with the account, so that you have, you have to show up with your certified copy of the power of attorney to say, I am the power of attorney for Matt Bruning. That gives you more access, frankly, than even this bill does. But if it's something where we suspect abuse, or there's fraud occurring, we can at least reach out to that power of attorney if we have it on file. I think for those folks, it's a little bit broader on what we can provide, depending on what the power is, with the power of attorney. We might be able to discuss, these are the actual transactions versus this bill, which just allows you to say, we think there's something happening, you need to talk to the person.
Mr. Bruni, let me ask you, is this bill really about what's contained down on line 39 through 41? A financial institution or financial institution staff shall be immune from any criminal, civil, or administrative liability for any act taken or omission made in accordance with the provisions of this section. So if you don't turn somebody in, you're immune. If you're dealing with somebody that's a bad guy, and you're doing so in good faith, you're immune.
Mr. Chairman, I think, that's certainly part of it, but right now, under Virginia law, and with our federal regulations under Graham Leach bylaw on who we can talk to about personal financial information, we can't go out and have a trusted contact, somebody on the account that is just for contact purposes for these instances. So again, we have the immunity language certainly in there on our liability when we do reach out or choose not to. But this really does facilitate another option. It's, again, building on the progress we've made, working with Senator Obenshain, Senator McPike, and we certainly appreciate Senator Favola putting this forward. It's one more step in our attempt to prevent and combat these elder financial abuse. But certainly liability protection is important to it, but just the enabling authorization to be able to make those contacts, to take a person, put them on the account listing of trusted contact is something that is new in Virginia law.
Mr. Chairman. So, Mr. Chairman, Senator Full, I think this is a good bill. My time when I was in law enforcement as a detective, I actually worked a case where the granddaughter would take her grandfather, who had cognitive impairment, to the bank every day. The problem that I want to get to is what Senator Deed just mentioned. The girlfriend's boyfriend worked at the bank. And so I think this last section kind of gives me a little trouble because he was working with the granddaughter. So does this mean that he can't be charged for the fraud that she was committing on the grandfather, draining his account every day, coming in person in the car, but that her boyfriend worked for the bank and was doing the deposits or withdrawals, excuse me, Mr. Chairman.
Mr. Chairman, Senator Reeves, that is a very specific instance. I understand what you're getting at.
Mr. Chairman, could General Counsel answer that?
I think this is kind of limited just on to the being able to reach out to the trusted contact or the person, but not on the actual.
Yeah, the point he makes, though, might be a loophole in the language, and Tom, maybe.
I hear you.
We may have to tighten it.
Mr. Chair, Senator Reeves, in sub E, the liability section, shall be immune from any criminal, civil, or administrative liability for any act taken or omission made in accordance with the provisions of this section. I don't know that, I believe the scope of the immunity is within the provisions of this section. So if you violated criminal code, that subsection would not apply. But certainly if you want to work on some language, I'm happy to do so.
Mr. Chairman, I'm not an attorney. I was a cop, but I just, the last line 39 says any criminal, 2 words, from any criminal.
Mr. Chairman?
Senator Eben.
Just in response to Senator Reeves' concern, it's only, you're only immune from prosecution if it was an act taken or omission made in accordance with the provisions of this section. It doesn't provide immunity for other acts, as our counsel told us. So I'm comfortable with that provision the way it's written personally.
Mr. Chairman, again, I think it is limited just to this section as far as if the financial institution staff in good faith reach out and maybe they say, oh, and they sent a $5,000 wire to the Nigerian prince, that may be in violation, frankly, of what we're allowed to tell on financial information. So that would make them immune from that piece. If they're working with somebody to actually exploit the person, That, I think, as council referenced, doesn't apply on this section as far as immunity. They'd still be subject to criminal and civil, liability on that side of things.
Well, I'm concerned about what criminal liability would exist under this provision. I mean, I am concerned about any language that limits potential criminal liability. Tom, maybe you can tell us what sort of criminal liability or criminal charge would flow from this section.
I think we just lifted it from something else.
This section further.
Again, Mr. Chairman, the only thing I can think of, and again, we probably lifted this off of some of the language we had in 63.2 on some of the other, tools in the tool belt we have. The only thing I could think of is, again, if you release personal financial information of somebody, again, that's going to end up being more probably civil, but there might be some criminal piece to that. That's a little out of my non-lawyer bounds, but if there's comfort in taking and striking criminal.
Yeah, we're happy to do that if that helps.
That might make.
I'll make that motion to strike the word criminal.
Okay, is that? Okay, we had a motion and a second to strike the word criminal on line 39. All in favor of that, say aye. Aye. Any opposed? Okay, we've made that further amendment to the bill. Are there other questions? Senator Eben.
Briefly, and I have a motion afterwards. Is ARP have a position on this bill, or did you work with them at all?
ARP came to my office this morning and said they were in support of the bill. Jared was here. Oh, there you go.
Thank you, Mr. Chairman. Senator Eben. Yes, ARP does support this legislation. I won't bore you with all the statistics about fraud and financial exploitation, but it is very significant. And the older you get, the higher the number goes in terms of if you're defrauded or financially exploited. If you're over 80, you lose 4 times as much as somebody in their 20s. And so, what this bill does is it gives our financial institutions another tool in the toolbox to help prevent some of this stuff, because once you've been exploited, the odds of being made whole again are very, very low. So I think prevention is the key. And I'm also comfortable with the amendment that struck criminal, because I do think that it's a smart idea by the committee to, ensure that no one is given immunity in the situations that the senator described, where somebody working at the bank is trying to help exploit someone.
Okay, Senator Eben, that's
for the AARP.
Hold on a second.
That completes my question.
Senator Obenshain.
Mr. Chairman, since gentleman from the AARP referenced statistics, isn't it true that the overwhelming majority of financial exploitation of elders is committed by a trusted person?
It is, yes, sir. And so I understand your concern with, instances where the trusted contact might be the person engaged in the exploitation, but I would say that's what's happening right now. And, your average person has a lot of people that know them and know them well that might be exploiting them, but in general, they would be more likely to list a trusted contact as someone really, really close to them, that, a sibling, a parent, a child, someone like that, whereas they're more likely, not more likely, but they might be exploited by a cousin or someone more distantly related to them. So if they can put a list of who their trusted contacts are and really narrow that down to the people they trust the most, I think that would be a positive thing. But you are correct that people are exploited more often by someone that they know rather than a stranger.
Okay, Senator Stanley.
I would just reiterate, in answer to that question, is if the bank does believe a trusted individual is the exploiter, they can go right to adult protective services.
Okay, Senator Eben, you had a motion. Do you want me to can I ask for witnesses first and then?
Oh, please, yes.
Okay, are there those in the audience who would like to speak in favor of this bill? Or those, okay, come on up. And do it in a minute, please.
Yeah, right. He needs to say that. Good afternoon, Mr. Chair. I'm C.J. Vatipelson with the Virginia Credit Union League. Credit unions are in support of allowing for trusted contacts to help prevent abuse and exploitation of the elderly and other individuals. Thank you.
Thank you, sir. Okay, is there anyone who wants to speak in opposition to this? Okay, Senator Eben.
Yes, we'd like to move to a report and Move to report.
Move to report the bill. Is there a
As
second?
amended.
Motion made and second. Are there other motions? Is there further discussion? If not, open the roll.
Ayes 15, no 0.
Thank you, Mr. Chairman and committee members.
Wow. Senator Diggs, you're next.
Thank you, Mr. Chairman, and I hope to continue Senator Favola's success today. Senate Bill 202, I have an amendment in the nature of a substitute.
What's bill number 202? Okay, is there a motion on the substitute? Okay, got a motion and a second on the substitute. All in favor, say aye. Aye. In opposition? Okay, the substitute's before the committee. Senator Diggs, tell us about the bill and tell us about the changes between the bill as drafted and the substitute.
Yes, sir. The substitute is just a much simpler process than the original bill. It was discovered that this was an easier way to get there. The substitute only really reduces the threshold of from 100 to 50 for a claims experience. And the purpose of this bill is to allow policyholders to have access to information that would be useful to them in rebidding, modifying, or amending an existing policy they may have, and helps independent agents move that along so that they can pass those savings along to the consumer.
Tom, when we were talking, this is a method you identified for simplifying this bill, isn't it?
Yes, sir, with apologies to Senator Diggs, Mr. Chairman. The bill was introduced, it created a new code section. We already had some of this in existing law, and so he just wanted to lower the threshold of individuals from 100 to 50.
Okay, this is pretty simple. Okay, are there those in the audience who would like to speak in favor of this bill?
Hello, George Clark. I'm an insurance broker from Yorktown, Virginia, and this is a bill that, thank you, Senator, I'm just calling you Sheriff, Senator, for carrying this. This is just something that we really need to, it's a transparency thing. So when we go to shop our rates every year, we get a list of what the claims were, not the individual, so there's no HIPAA violations. And with that, we know who we can shop it with. And sometimes those people that had those high claims are no longer with the employer. So at that point, I can go to another carrier and say, hi, by the way, we don't have to carry this claims experience with us, and it keeps the rates lower. Currently, a good many of carriers are already doing this. Some have just kind of stopped, some just kind of give a little bit of information. We're just looking for uniformity, and this will just save employers and families money in the long term.
Okay, thank you, sir. Are there,
Thank you.
Are there those who would like to be in opposition to this bill? Mr. Gray.
Mr. Chairman, Doug Gray for the Virginia Association of Health Plans. We can provide this data. We do in some instances. We do have some concerns about privacy. I mean, if you are in a employer of 60 people and you get claims information that show large claims, you may be able to figure out who it is. And that's something that the committee has to decide whether they're comfortable with. I think sometimes when the plans choose not to send the data, it's because of those concerns. And one of the things I think we need to make sure of is that the plans can say that they won't provide the data if they're afraid that it will make it possible to identify someone. And the last thing I would say is most of the data is around trends when it comes to this size group. It's not underwritten just by the group and their experience. It's broader trends that really drive what happens. And those things are frankly shared pretty easily.
Senator Servel's got something.
I have a question for somebody, either Mr. Gray or I've forgotten your name, but
George Clark.
Mr. Clark. Yeah, so I mean, this isn't only about the claims experience of the employee. It's also potentially, if the employee has themselves on family coverage, it could be disclosed in the claims history of people in their family that aren't employed by the employer, right?
No, it never tells it never has a name attached to it. It only has the condition and what the claim was, nothing
Mr.
else.
Chairman,
Senator Surville.
I understand it doesn't have the name, but the point is if it's a small enough group and you know that so-and-so's wife had breast cancer and you see a big number or whatever, then you could connect the dots to realize that that's who it was and that's what was spent, and then you see the procedures and lots of other things, right?
You would hope that you would do the right thing because you can do that with every group right now anyway. Whether you've got 99 employees or 101, you can figure that out. So at that point, there are HIPAA laws to protect citizens from that. And I haven't, again, carriers are already providing this information, just not all of them. And I haven't seen any lawsuits flying around. I haven't seen any abuse of it. And I don't expect to see any abuse of it.
Mr. Chairman.
Senator Surville.
I know, but you keep missing my point.
Oh, I'm sorry.
I understand they do it now. They do it now with companies that employ 100 people. With 100 people, there's a lot less risk of connecting the dots than when you have smaller companies like my law firm that only has 50. And so it's a lot easier to connect the dot when you know, because you know your employees a lot better when you're smaller and you know about things they maybe have had going on themselves or in their family. So there's a lot more risk of connecting the dots, which is why the threshold was higher, which I think is what Mr. Gray is trying to tell us about when we reduced it to 50.
Well,
right?
No. Quite honestly, because I know all of my employees. I insure over 10,000 people. I know just about every one of those employees through the years. Through their HR people know them directly. Everybody knows directly. This is a bill that will help save money in the long haul. It's not something that's going to stop anybody from doing criminal and abusing HIPAA laws. There's HIPAA laws to protect these people. So, no, I respectfully disagree with that. I believe that the same opportunity, it's there whether you've got 150 employees or 75. The same risk is there for personal health information to be shared.
Are there additional?
Thank you.
Is there anyone who wants to speak against the bill? Anyone? Okay, there was a motion to report and a second. Are there other motions? Open the roll.
Ayes 7, noes 8.
Ayes 7, noes 8. The bill does not report, Senator Diggs.
Thank you, Mr. Chairman.
Thank you, sir. Okay, next on the list is Senator Williams-Graves. Senator Williams-Graves, what's your bill number?
It is Senate Bill 520, Mr. Chair.
520.
Yes.
Turn your attention to Senator Williams-Graves.
Thank you, Mr. Chair. Members of the committee, Senate Bill 520 is a bill to amend and reenact Code 65.2-400 of the Code of Virginia relating to workers' compensation injuries caused by repetitive and sustained physical stressors. The toll of workplace disease and injury in an individual worker and their family is enormous. Medical bills and loss of time from work-related illnesses and injuries can be a massive burden on workers and their families, not to mention the emotional and financial consequences of losing a family member to a workplace fatality. Workers' compensation provides a crucial source of health care coverage and income support for the sick or injured workers. Yet, according to JLARC's own report in 2019, Virginia workers' compensation system could benefit from such much-needed improvements. Since then, the insurance and business lobby have been successful in kicking this ball down the road, claiming the issue needed further study. The time is now to pass the bill, and it is long overdue for reform. Senate Bill 520 brings Virginia in line with 49 other states on repetitive injury coverage. Under the current Virginia Workers' Compensation Act, in order for a claim to be compensatable, Workers have to be able to pinpoint an exact beginning and ending time of when the injury occurred. This is uniquely rare. This is a uniquely rare standard, with Virginia being the only state where employers do not have to compensate work-related repetitive injuries. This is nothing for us as Virginians to be proud of. This legislation would make the workers' compensation system far less complicated. Senate Bill 520 will especially benefit workers employed in plants and other workplaces where repetitive activities are a normal part of the work day. In summary, this bill provides, for the purposes of Virginia's Workers' Compensation Act, occupational disease includes injury or disease from conditions resulting in repetitive and sustained physical stressors, including repetitive and sustained motions, exertions, posture stresses, contact stresses, vibrations, or noises. The bill provides that such injuries or diseases are covered under the Act, and that such coverage does not require that such repetitive or sustained physical stress occurred over a particular period, provided that the time period over which such sustained physical stress occurred can be reasonably identified.
Look at this. There's the occupational disease. Maybe this isn't for council. Occupational disease requires proof by preponderance of the evidence. Is that correct?
Mr. Chair, yes, sir. Preponderance is the standard for occupational disease. If it were an ordinary disease of life, it's a higher standard.
And that's clear and convincing evidence.
Yes, sir.
So is this statute clear with this bill, clear with respect to whether this is going to be provable as an occupational disease or as a ordinary disease?
Mr. Chair, I believe it is. Certainly, if the Workers' Compensation Commission is here, they can correct me if I'm wrong, but I believe on line 20, notwithstanding prior decisions to the contrary, any such injuries or diseases shall be covered if shown to arise out of and in the course of employment as provided in this section. And this section, subsection B, is the six-part test that occupational diseases have to meet.
Are there questions for Senator Williams-Graves? Okay, are there people here that would like to speak in favor of this?
Yes.
About a minute apiece, okay?
Dr. Emily Yen, VEA. We strongly support the bill. We think that it's really important to take care of our workers who are injured on the job through repetitive stress injuries. In addition to providing this benefit to injured workers, we think that this will also encourage employers to take prospective measures to reduce the likelihood of repetitive stress injuries through adopting a variety of measures. Thank you.
Okay, thank you, ma'am. Next.
Mr. Chairman, members of the committee, Jennifer Pike on behalf of the Virginia Professional Firefighters, and we support this legislation.
Okay, thank you, ma'am. Next, come on up.
Mr. Chairman, members of the committee, Brian Payton on behalf of Teamsters, we support this bill.
Okay, thank you, sir. Next, come on up. Just come on up.
Good afternoon, members of the committee. Julia Newton, SEIU, and we strongly support this bill. Thank you.
Okay, thank you, ma'am.
Good afternoon, members of the committee. My name is Kayla Mock. I'm with the United Food and Commercial Workers Union Local 400. We also strongly support this bill.
Okay, thank you, ma'am. Come on up.
Good afternoon, Mr. Chair, members of the committee. My name is Celeste Armstrong with United Steelworkers Local 8888, and we strongly support this bill.
Okay, thank you, ma'am. Come on up.
Mr. Chairman, ladies and gentlemen of the committee, I'm Luke McCann with Local 8888, strongly supporting the bill as well. I would like to point out that Newport News Shipbuilding, being one of the largest employers in Virginia, has a hard time finding skilled people even to fill the positions. And a consideration when it comes to these things being in the repetitive motion of injury may discourage people from coming into it, creating a domino effect that goes all the way to the Navy's mission. And so in short, I believe this bill is good for workers, good for the long-term health of the Virginia economy, and good for our national defense. Thank you for your time.
Thank you, sir. Okay, come on up, sir.
Thank you, Mr. Chair. Jason Parker, Virginia AFL-CIO, Virginia Building Construction Trades Council. We support this bill. In the construction world, a lot of our jobs, they're not ergonomically correct or tough on the body, and over time you get worn out. You see it a lot. If you want to keep your tradespeople, you got to have some of these protections for them as our workforce ages. Thank you very much. We support.
Thank you, sir. Is there anybody else in favor? Okay, anybody in opposition? We've got a few.
Good afternoon, Mr. Chairman, members of the committee. Jeff Smith here on behalf of the Virginia Self-Insurers Association, as well as Metis Holdings, a company that oversees all of VACO's risk liability claims. I first want to thank the patron. She was very generous with her time when we came out to talk to her, and I'll also be mindful of the committee's time, and I'll be brief. Our concern with the legislation is that it's very broad and that there's very little protection on the employer side as far as being able to defend itself and show that the injury did in fact occur on the work in the workplace. I'll say it alters the current framework that we have for carpal tunnel and hearing loss that were agreed to be covered as repetitive motion injuries some years ago. Those are currently under the Ordinary Diseases of Life section, and this bill takes them from there and puts it into the occupational disease. And the system seemed to work pretty well for a while. We're not sure why it's being changed. And also bring your attention to the physical impact. The bill does have a pretty substantial cost. So when you add local governments on top of that, as well as private sector employers, this bill is pretty significant. And so want to bring that to your attention. Thank you.
The bill will have to go to finance if it's reported.
Good afternoon, Mr. Chair. Karen Addison with Trotman Pepper Strategies, representing American Property Casualty Insurance Association. Our members write over 80% of the workers' comp premiums in Virginia. And we very much would like to work with the Senator and would support Senate Bill 520 with two amendments that were recommended by the 2020 JLARC study. First, a documentation of the period of time that the physical stress occurred, and second, showing that the injurious exposure from employment primarily caused the injury. So those are the two items that we would very much appreciate including. Thank you.
Thank you, ma'am.
Mr. Chairman, members of the committee, Jody Roth on behalf of Virginia Retail Federation. We also oppose this bill for the reasons just laid out by Mrs. Addison and Mr. Smith. Also, my members do consider legislation like this a job killer, and why more and more my members are moving towards self-checkouts. Thank you.
Thank you, ma'am. Senator McDougall has something.
Mr. Chairman, I'm just trying to understand a little bit. If, I guess in lines 18 through, 20, it talks about you don't have to determine that repetitive, that stress has been over a particular time. So, Mr. Chairman, my question is, if you have somebody who worked at a similar business for 10 years and then you hire them and all of a sudden they're with you for 6 months and they get the injury or the purported injury, how do you not protect yourself from saying that occurred somewhere else, not just at yours? Because what's the protection for the business individual that hires somebody who's been in that situation?
Mr. Chair.
Answer for that, Senator.
Mr. Chair and Senator McDougall, I would venture to say that if someone worked somewhere else doing any job and then they changed jobs and went to another job and were hurt, we still have no way of knowing if the injury that they sustained and the depth of the injury that they sustained came from the job that they're on currently, or if there was a pre-existing condition. Right now, the goal is to protect workers and not exploit them and their injuries from repetitive motion.
Okay, are there additional questions?
Mr. Chairman, I don't know that I have a question. I just maybe have more of a statement. Because my concern, I grew up, my mom has a plant business, and we grew up picking things up. So mom's had multiple carpal tunnel surgeries. I understand that. My concern is what happens if she hires somebody that's been a typist all their career, they want to work for her, in 6 months with her, all of a sudden they say, oh, I have carpal tunnel. What's to protect her from hiring somebody? I think I understand the goal, but it needs to be a balance. And I think that the not having any time period requirements skews the balance in the other direction. There has to be something that puts the injury with the employer, not just that there's an injury. And that's the way I read this. If you have an injury at an employer, regardless of on these potential long-term items, it doesn't matter if it is a result of being with the employer. The fact that you have it now is creating the liability on the employer. I think that's concerning.
I'd like to send a helpline out there. Is there a lawyer in the crowd that does workers' compensation work? Sure.
My name is Brad Goodwin. Thank you all for having me this afternoon. I am a workers' comp attorney, and I'm happy to address these questions. I apologize. I did walk in kind of in the middle. I just actually got out of workers' comp hearing a moment ago, so I'm here, and I'm happy to address any questions.
Well, just explain how this bill would change existing law.
Absolutely. So as was discussed, is currently you need to identify a sudden, immediate moment. So the example I always give my clients is if you work at Amazon and you're lifting boxes all day and you say, gosh, my shoulders hurt at the end of the day, you're not covered. What you need to have is that I was lifting box number 217 and I felt the pop in my shoulder, and that's the exact moment that it happened. No, you don't need to count the boxes, but my point is that you have to identify that sudden moment. So this will change the law in the sense that repetitive natures will be covered. Now, a concern I think I heard was, well, how do you pinpoint it on this employer, or how do you point it to this somebody who may have prior history or other things? The claimant still has the burden of proof. They still have to prove that this injury was caused by the work. So not every time somebody says, gosh, my shoulder is hurt, do they automatically get workers' comp because this bill now allows repetitive motion. They're still going to need a medical doctor to say, that shoulder injury was caused because you've been lifting boxes at Amazon all day. So if you volunteer for your son's baseball team and you're throwing batting practice every day after work, or you golf all the time, or you lift weights, or you have a pre-existing shoulder injury, you're still going to have that burden of proof to show my injury is because of my job. It's not automatic. It's not expanding the rights in that sense. It's merely saying that if you can prove that your injury is because of your job, you should be entitled to benefits. And to me, that makes perfect sense. The only issue right now is in Virginia, which is the only state that does this way, is it has to be a sudden, immediate thing and not something that's from over time, even if you prove that it was related to the job.
Thank you, Mr. Chair. So I guess what you just explained to us is I guess line 19 halfway, specifically after the comma on line 19. So long as the period of time over which such physical stress occurred can be reasonably identified. Is that pretty much sums up what you just said, or can you clarify that?
Correct. Yeah. So there's still a need, again, to relate it to the employment to show. And so reasonably identified, what does that mean, right? Well, obviously, currently that pop, that sudden moment is covered. But now we're talking about, okay, well, over a period of time, reasonably identified, which again, I think alleviates the concern that, well, how do we know this hasn't been going on the whole life? Well, now you have somebody who says it's been going on for the last 6 months. It happened yesterday, some point. Maybe you have somebody who doesn't lift boxes all day, but yesterday they lifted boxes all day and now their shoulder's hurting. If they can tie it to that reasonably identifiable time, then it's covered. And it could cover somebody who's been working there for 6 months and gradually occurs. That's the point of it. But you do have to identify that. You do have to be able to relate it. So I think that is exactly tied to what I'm saying.
Thank you, Mr. Chairman. My question, Mr. Chairman, is actually to Ms. Addison or the patron. Was there a proposal time duration? Because I can see from Senator McDougall's position of someone on the job in 6 months coming up with someone, other occupational diseases, we do have sort of qualifiers in terms of time, durations, and limits. Was there a discussion of language around that, similar to other code sections that we already have on the books? So it's not the question unless you were in the room. The question is, was there compromise, discussion, or language offered?
Mr. Chair and Senator McPike, there was some conversation around language. We ran all of the conversation and the request through our partners with labor, and they were not happy with the conversation of the structure of the language. That language came from insurers.
Follow up, Mr. Chairman. Was there discussions around setting a year, 5 years, 10 years, or some employment period that someone would qualify? Just curious of how the mechanisms would work. Was there a date or number offered?
Mr. Chair and Senator McPike, I do not remember, to be perfectly honest with you, what the structure of the conversation was, but there were some parameters that were offered. But I really don't remember the specifics.
If I understood correctly, the evidence still has to prove that it's related to the specific employment. Is that correct?
Yes, Your Honor. Yes, sir.
So I think whether the time period is in the code section or not, the evidence still has to prove that it's related to the employment.
Mr. Chairman.
Senator McPike.
Follow up. In other sections of our code, we do have qualifying in terms of years within that service, and that was my point of my question. And I don't know if Ms. Addison could answer. She referred to it earlier, but did not specify a number. And I was interested in a number for the committee's edification as well.
I think Ms. Addison's, her point was to turn part of this, what this bill accomplishes or seeks to accomplish, is to do away with the time period, and she wants to put it back in there. She wants to have an accident arising out of and of the course of employment, and that pretty much is gone from this bill. Is that pretty much sum it up?
Yes, sir. I'll be happy to read it.
Okay. Well, yeah, come on up, Ms. Addison, come on up and read the language.
Thank you, Mr. Chairman. I'm sorry for the confusion. The language would have been after identified on line 20, insert and documented, and further provided that the injurious exposure from employment is shown to have primarily more than 50% caused the injury, considering all causes. So there was no timeline, Mr. Chairman.
Okay. Senator Morrison's got a question.
Thank you, Mr. Chairman. Karen, question for you. Would adding this to the code, would this place significant or de minimis, cause significant or de minimis increases in workers' compensation insurance costs for employers?
Mr. Chair, may I clarify that would the bill itself or would the amendment?
I'm sorry?
Are you asking the bill itself, would it?
The bill itself.
Yes, sir, we believe so.
Senator Eben?
Yeah, for Ms. Addison. Ms. Addison. Karen, I wanted to ask, you identified some language that can reasonably be identified and documented, and I was wondering this phrase undocumented, does that mean someone has to keep a logbook, or if they lifted boxes for their job all day at that job, why do they have to document it? If it could be identified and the doctor can say it's from that, why is that not enough? Why do you have to have a logbook that said you lifted boxes on Monday, Tuesday, Wednesday, Thursday, Friday for 80 days if all you do is lift boxes at the job and you tell the doctor that you're not lifting weights on that same shoulder, just boxes?
Yes, sir.
Why document which days you were doing it?
Mr. Chairman. So, Senator, I'm afraid I'm a little in deep. I might have to call a lifeline if there's anyone who might be able to assist. But I think the idea was to at least provide a little bit more connection between the injury and the job. So that's why the documentation is a little bit vague.
I think your lifeline's arrived. Sorry, Mr. Chair.
Not a good lifeline, I'll admit. But I do think as far as documentation goes, where as far as the employee, it's within the job description. You are stacking boxes, you're driving a crane, or working at a grocery store. Kind of, it's in your job description, and that's part of what the documentation entails. Again, that is a little broad, but
if I could follow up, Mr. Chair, is it necessary to document it? I mean, what if you have a supermarket job description that you're a clerk and you do stock and putting things on the shelves? Do you have to have it in writing that that's part of your job, or is it not enough to testify under oath that you were stocking the shelves 100 days before? I
think you would probably take them both together. But I think just having the documentation, I still think it's a big jump, even with the language for the employers. I think we're just trying to find something in there that will give the employers some kind of protection. Again, it's small, but that was an approach that we had. So,
thank you.
Other people in the audience that will speak to this bill, not the bill before the bill before the committee. If it's reported, it's got to be re-referred to finance because it does has fiscal impact.
Mr. Chair.
I'm sorry, Senator Williams-Graves, you certainly have the last word. I apologize.
Thank you. I appreciate that. I just would like to note that carpal tunnel and hearing loss from work environments are not ordinary diseases of life. They might be if that is not your work environment, but if that is your work environment, they are not ordinary diseases of life. And that we only get one body. And when we use that body repetitively to earn a living, then Virginians should be covered if they're injured on the job from repetitive motion in earning a living using their bodies. Other states have found the dollars to do it, and I believe, and they've also found it necessary to protect their workers, and I just believe it's time for Virginia to do the same. Thank you, Mr. Chair.
Thank you, ma'am. Got a motion to report and a second. Are there other motions? Is there further discussion? If not, please open the roll.
Ayes 8, noes 6.
Ayes 8, no 6. The bill goes to finance.
Thank you, Mr. Chair, members of the committee.
Senator. Okay, Senator Van Valkenburg. And I think you've got 360. Is that correct?
Yes, Mr. Chair. And Mr. Chair, before we started, there's a clarifying amendment that if we could adopt, and then I'll explain when I explain the bill.
Okay. Do we have the amendment?
Council.
Mr. Chair.
This is a covenant not to compete bills.
Senator Van Valkenburg, after lines, so at the end of the bill, insert a second enactment that the provisions of this act shall be applicable to covenants not to compete that are entered into on or after July 1, 2024.
Mr. Chair, if he could please repeat that. I honestly couldn't hear with the
I couldn't hear
folks
it
leaving.
either.
Thank you, sir.
Please repeat it.
Yes, sir, Mr. Chair. At the end of the bill, insert a second enactment. 2, that the provisions of this act shall be applicable to covenants not to compete that are entered into on or after July 1, 2024. So it's making sure the bill is prospective and not retrospective.
So it has no retroactive effect. Okay. Okay. Motion's been made and seconded on the amendment. All in favor say aye. Aye. Opposed, no. Okay, the bill's been amended. Senator.
Thank you, Mr. Chair. Mr. Chair, members of the body, Senate Bill 360 is about non-compete agreements for healthcare professionals. And so this builds off of bipartisan work that we passed in the General Assembly in 2020 when I was on the other side of the Capitol, and Senator DeSteph carried it in the Senate, where we banned non-compete clauses for low-wage workers. And after we passed that legislation, I had an outpouring of people in the medical world that came to talk to me about the non-compete clauses they were under. I had a doctor in Chesterfield who moved to Ohio to get out from his non-compete clause. And so that's kind of the genesis of this bill. Virginia is facing a healthcare professional shortage, like many people are. With low-wage workers, when they get a non-compete, when they could have a non-compete clause put on them prior to 2020, often that just means they can't get another job. You're a hairdresser, say in Short Pump, and then you can't work as a hairdresser anywhere else in the Richmond area. Well, with medical folks, they have the disposable income to move. So if they have a non-compete clause, they can move to get out from under it, but that means we're losing talent. We're losing medical professionals who are not staying in our regions and are instead, moving elsewhere. And so this would just extend to healthcare professionals what we did to low-wage workers to make sure that they had the freedom to move. This is good for free markets. This is good for workers. I'll keep it short because I know you guys have a long docket. The last thing I'll add, and I know there's some people that want to speak to it, is that we have a complete ban on non-compete clauses in 3 states, Oklahoma, North Dakota, and California. And we have bans on non-competes for physicians in Rhode Island, Massachusetts, New Hampshire, and Delaware. And so this is something that's being done. I think this is a good thing to do. I think doctors, nurses, and other healthcare professionals should be able to move around if they want to move to another job and shouldn't be non-competed.
All this bill does is remove the low-wage language. It's just
all it does is add healthcare professionals to that language.
For healthcare professionals, yeah.
Mr. Chairman.
Okay, Senator McDougal.
Mr. Chairman, why wouldn't we want to be like one of those other first 3 states you talked about? Why do we want to, I guess, Mr. Chairman, why do we want to go down and start picking individual industries? Why don't we just say we're against this?
I'm not saying,
Stanley might need a job
I'm not saying
at
that
some
we
point.
want to be like those 3 states. I'm just saying that it's happened in these other states and the sky hasn't fallen in the healthcare sector.
I guess, Mr. Chairman, my question is more, why wouldn't we just say no non-competes?
You mean universally?
Time to get his own bill.
Mr. Chair, if you guys want to get crazy and you want to ban them all together, I'm here for it. I'm trying to solve an immediate need in a sector where we're seeing a lot of non-compete clauses, and that's hence the bill.
Okay, are there additional questions for Senator Van Valkenburg?
And I know we have people that would like to speak to it as well.
If there are people that are here to speak in favor of this bill, come forward.
Mr. Chair.
Senator Peake.
Yes, one question, and it might be council, but isn't there a fairly recent case, either state Supreme Court or Fourth Circuit, that Virginia's almost done away with enforcement of non-competes? Has anybody got a civil lawyer familiar with that?
So I can answer that question, Senator Peake, Mr. Chair, because this came up with the prior bill as well, which is you eventually can take it to court and get them wiped out, but of course you have to go to court, you have to get a lawyer, you have to go through the process, and so you shouldn't have to do that to be able to move to a new place of employment.
Senator Peake.
Was there a recent case? Not familiar.
Mr. Chair, I'm not sure about the case itself.
All right. Thank you.
Okay, people that want to speak in favor of this bill, please come forward. And be brief if you can.
Good afternoon, Mr. Chair, Senator Deeds, and other members of the committee. I'm Dr. Persida Ellis, and I'm a pediatrician in Rockbridge County. Today, I'm actually representing the Virginia chapter of the American Academy of Pediatrics, and we are in support of SB 360. As a physician in a rural, underserved area, I have seen how non-compete clauses hurt our communities, especially we being already in desperate need of recruiting more providers. So non-compete clauses basically force providers to leave the community, or they would be forced to choose between what might be a difficult working environment or simply having to uproot their families and moving. This in turn impacts the patients and interrupts their continuity of care. Oh, sorry. So a provider in this scenario, you could say, well, they could join a practice that does telehealth. But the problem is that in rural areas, there is a lack of broadband access, or if there is access, it is very inconsistent and not stable. So a physician who has chosen a rural community like mine to make a home, raise a family, and provide health care deserves the flexibility to change employees when necessary. And they should be able to do so without the threat of having to leave their community and uproot their families. And so it's for these reasons I ask that you support SB 360. Thank you.
Mr. Chairman, my name is Dr. Jeffrey Green. I'm an anesthesiologist here in Richmond. Today I'm speaking in support of 360 on behalf of the Virginia Society of Anesthesiologists, where non-compete agreements make it very difficult for anesthesiologists to obtain employment in the Commonwealth, and this bill would help to improve the job market for anesthesiologists. Thank you.
Mr. Chair, members of the committee, Brent Rawlings for the Virginia Hospital and Healthcare Association. We're opposed to the legislation. We've spoken to this measure in previous sessions when it was introduced. Just kind of high-level concerns we have. We definitely hear the concerns about workforce, and I think that points out something important about these non-competes. They're an effective tool in recruiting and retaining healthcare professionals, particularly in rural areas. Oftentimes you see a non-compete included in an employment agreement, but there are also other agreements wrapped around that, including provisions for loan repayment for physicians to recruit them to the area, provisions to provide them with incentives to establish practices in that area. So it's not a standalone blanket non-compete agreement. It's part of a larger arrangement. And that to follow along with that, you're adding to a bill that is singling out healthcare providers as to all other workers, and it's equating them to low-wage workers. And in the instances where these are used, we're not dealing with low-wage workers. We're dealing with sophisticated parties and business arrangements.
Let me ask you if I can, though. We've got shortage across the board for healthcare workers, right?
Correct.
Okay, how many of these covenants not to compete have been enforced in your industry in courts in the last 12 months?
Mr. Chair, I couldn't answer that question. I mean, I think that raises another point, which is that the courts are available to intervene where a covenant to compete is too broad. I mean, you couldn't enter into a covenant compete in Virginia that's enforceable that would prevent somebody from moving elsewhere in the state, perhaps. Moving to Iowa, the scope has to be very narrowly tailored, and so there's a lot of scrutiny on these already that prevents them from being too broad. And again, they're used sparingly as part of larger arrangements, and the feedback we've received from our members is they are used for recruitment and retention to get people to come to the areas where those specialties are needed and are lacking. And it's just a tool on the table. It doesn't mean that it's a mandate for everyone to use, but it's available to us, and this would create a disadvantage for those efforts. And so for these reasons, we are opposed to the legislation.
I think Senator McPike has a question.
Thank you, Mr. Chairman. A question to the Speaker. You know, if you have enticements or incentives, don't you already have built-in clawbacks built in, whether it's housing, loan repayment, all these all have, they're independent items that you're trying to tie into it. I don't understand the nexus between non-compete and the other benefits that you're providing. If someone chooses to do it, they do away with that loan repayment, they're foregoing that opportunity.
And Mr. Chair, just in response to that, depending upon the nature of the arrangement, yes, that would be true. But also just keep in mind that think about the context here. If it were a recruitment arrangement, an establishment of a practice, an investment in that individual, building staff around that individual, and then to expect the possibility that individual could then, after learning all of that information, move across the street and set up a competing practice, it undermines the investment that's made in that business. So again, these are business arrangements among sophisticated individuals represented by counsel, not boilerplate provisions in employment contracts.
Mr. Chairman. Mr. Chairman, I find that point interesting, but I would suggest that maybe the more frequent use of non-competes are for small non-hospital affiliated practices or pharmacies that are not parts of major chains who are trying to bring professionals to their community and have over the years experienced maybe
what they perceive as predatory practices by folks who'd rather there not be these independent pharmacies or small practices in their community, and they utilize non-competes to try and preserve their ability to operate in the community and not have their personnel that they spend a lot of money bringing to the area poached because they all of a sudden become very popular. So I think that this also goes the other way too, and I see some value in keeping the practice.
Hi, I'm Dr. Wendy Klein. I'm a physician in the community, and I just have to comment on this bill. I wonder who benefits from non-competes. I always wonder about that because I've seen so many of my fellow physicians hobbled by non-compete clauses, and we clearly have a tremendous shortage. I would urge you to support this bill.
When we were looking for comments against the bill, you just...
I support...
Okay.
This is to remove non-competes.
Okay, she supports the bill. Okay.
Yeah, and my question for all of you is, who benefits? I mean, as a physician, I think it is nothing but cumbersome.
Okay, are there others in opposition to the bill? Okay, the bill is before us. We didn't get a letter from the powerful, all-powerful chairman of the Finance Committee that wanted this bill, so it has no state fiscal impact. So it's just, if the motion is to report, it's just a report.
Mr. Chairman, I move to report and one quick comment.
Okay.
This will be the ultimate Christmas tree bill, is my guess, on all non-completes, and we'll see this again and again.
You've got 4 amendment already in mind, huh? Okay, is there a second? There's a second. Okay, are there other motions? Is there further discussion? If not, open the roll.
Ayes 11, noes 2, 1 abstention.
Okay, congratulations, Senator Van Valkenburg. One step down. Okay, Senator Hashmi is the last non-committee member with the bill.
Thank you, Mr. Chair.
You're going to go first.
Mr. Chair and committee members, this is SB 238. And this is the Contraceptive Equity Act. Mr. Chair, you may recall that we had this bill in front of us, in front of the committee last year. It did pass out of the committee, also passed out of the Senate floor. And so we are hopeful that we will be able to successfully get it through both chambers this particular session. And as a reminder about what the bill does, this is actually not a new requirement in Virginia, but what we are seeking to do is to enshrine the popular elements of the existing federal law into Virginia code and to clarify any exceptions processes. So the bill addresses cost barriers to contraceptive access and equity by eliminating burdensome co-pays, cost-sharing, reimbursement requirements, and coverage delays. And it is something that replicates what's also happening at the federal level. As we all know, contraceptive care is critical medical care, and many individuals all across the country, here in Virginia as well, regularly use contraceptive medications to help with a variety of issues, not just to prevent pregnancies. Many individuals rely on effective contraceptive care in order to address issues such as endometriosis, uterine fibroids, gender dysphoria, ovarian cysts, and a variety of other concerns. So this providing equitable access to contraceptive care can actually help to prevent lost work hours, lost wages, and bring the kind of care that so many individuals need. I will share with the committee, and my apologies, we had some last-minute amendments, some technical amendments that were introduced. Council has it, but they're not ready to be distributed. With the committee's indulgence, indulgence. The parties who have participated in making those amendments, and those include Bureau of Insurance from SEC, Julie is here, Virginia Association of Health Plan, Doug Gray can speak to those. If the committee so indulges us, I'd like to bring these forth as floor amendments.
Well, let me ask you, this is a bill that passed out of this committee last year.
It passed out of
committee.
committee.
Passed off the floor.
It passed on the floor.
Was it pretty much a party line vote?
It was a party line vote.
And these amendments narrow it somewhat?
The amendments are technical. They bring into Virginia code into alignment with the standing federal regulations and CMS.
Is that your take on it, Mr. Gray? Okay. We could make the amendments here and then send it to finance, or? Okay. Are the amendments such that you can report, or?
They sent it to me at the beginning of the meeting.
Okay. Okay, well, let's just deal with the bill, and we'll if we decide to report, we'll have to send it to finance anyway, so that the finance committee then can then take up the amendments.
That would be wonderful.
Unless you want to
Thank
put
you.
it off another week.
I would not like to do that,
Okay,
and we
and
have
sit
many
for another
people.
couple hours.
Many people have waited patiently. They would like to speak to the bill.
I get it.
With the committee's indulgence.
Good afternoon, Mr. Chairman and committee members. My name is Lexi White. I'm the Policy Director with Repro Rising Virginia. I'm also here on behalf of the Virginia Reproductive Equity Alliance. I'm here today in support of Senate Bill 238 because Virginians need equitable access to contraceptive care, and this bill aims to eliminate cost barriers to this critical care. Everyone needs access to the full range of contraceptive options, regardless of their income. To be clear, this bill enshrines current federal law into our code, and contraceptives are overwhelmingly utilized and popular. Research shows that over 90% of women and gender-expansive people use some form of contraception spanning their reproductive lifetime. Some people use contraceptives to family plan, some use them to maintain or control hormone levels, and many women and people require some form of contraception, as the senator stated, to treat a range of healthcare conditions. Again, endometriosis, dysmenorrhea, even treating pain associated with uterine fibroids and ovarian cysts.
And if you could just be brief, and I'd ask witnesses to come, please be brief, because
Yes.
we heard this bill last year. Everybody on this committee was in the Senate last year, so we've all been subject to the information.
Wonderful.
So-
Again, just want to emphasize that contraceptive use helps to prevent unintended pregnancies and supports people in exercising their reproductive autonomy. Avoiding unintended pregnancies further can enable folks to complete their education, retain employment, and support themselves and their families. For all of these reasons, we urge your support for this bill.
Okay, thank you, ma'am. Please, next.
Denise Harrington, speaking in favor of the bill, the League of Women Voters of Virginia. The League of Women Voters of Virginia supports SB 238. We believe that contraceptives should be accessible to all and that individuals should be able to decide if contraceptives are right for them, not insurance companies. Having financial support without unnecessary expenses out of their pockets, such as co-pays, financial delays, and costly or delayed reimbursements, would help families utilize contraception without barriers. Additionally, according to the U.S. government data from the National Survey of Family Growth, contraceptives are not just prescribed as a form of birth control. And you've already heard numerous conditions. So thank you. We support the bill.
Ma'am. Next, please.
I'm Dr. Wendy Klein. I am an internist, and my area of expertise has been women's health for 35 years. I am co-editor of the Scientific Journal of Women's Health, and I'm here to ask you to support this bill. If you care about reducing unintended pregnancy, removing barriers to contraception is the way to do that. It's also critical for a wide range of reasons beyond preventing pregnancy, including treatment of menstrual and hormonal disorders, endometriosis, ovarian cysts, anemia, just to name a few. This bill would eliminate burdensome copays and alleviate economic and administrative barriers to contraceptive care. It is simply and unequivocally good health policy. In our efforts to improve the health of the citizens of our Commonwealth, I urge you to support this bill.
Good afternoon. My name is Galina Varchena. I'm the Policy Director for Birth and Color RVA. We are a doula collective of around 100 doulas across the Commonwealth, and we strongly support this bill.
Good afternoon, members of the committee. My name is Elisa Aldape. I'm a reverend here in the Commonwealth, and I'm also an organizer with the Latina Institute for Reproductive Justice here in Virginia. And as both an organizer and a pastor, I constantly ask myself, who is my neighbor? But more than that, I also ask, what does my neighbor need? And my siblings need affordable and equitable access to health care, and that is to say, affordable and equitable access to contraception. Access to contraception is a basic right and is an essential part to sexual and reproductive health. This much needed effort will mean that more people across the state, including Latina folks and other communities of color, can access and afford the care that they need. So I encourage you to support the Contraceptive Equity Act and eliminate cost barriers to keep our neighbors and all Virginians from living a safe and healthy life. Thank you.
Good afternoon. I'm Rebecca Gottwalt from Fairfax, Virginia. Contraceptive equality could have saved me a lot of time and trouble when I was young and exploring birth control options. I believe some methods weren't mentioned at all because I could not have been able to cover the upfront cost. We should always be working to improve situations for Virginians coming up after us. Contraceptive equality would make that just so. Thank you.
Mr. Chairman, members of the committee, Jeff Caruso with the Virginia Catholic Conference, speaking in opposition to the bill. So SB 238 requires health plans to cover everything the FDA defines as contraception. The FDA list of contraceptive drugs even includes some drugs that can cause abortions. Some faith-based organizations, including Catholic ones, could not comply with this bill. Unlike federal law, it contains no religious or moral exemptions whatsoever, and therefore would force these organizations to choose between following the law or following their deeply and sincerely held beliefs. This is in stark contrast with federal and state law, including the existing federal religious liberty exemption, the First Amendment, the U.S. Supreme Court precedent, and religious freedom provisions in the Virginia Constitution and the Virginia Religious Freedom Restoration Act. The Supreme Court's decision in the Hobby Lobby case and extensive litigation involving the Little Sisters of the Poor accentuate this point. Protect these fundamental religious liberty interests and please oppose this bill. Thank you.
Thank you, sir. Are there others who would like to speak in opposition to the bill? With this bill that we saw last year and passed out of this committee, will have to be amended, but it will have to go to finance where that can happen. And so a motion.
Mr. Chair, can I just
Senator
speak briefly to this? Mr. Chairman, members of the committee, there are parts of this that I have no objection to. The parts dealing with true contraception, I probably part company with my friends in the Catholic Conference in that regard, but this is a good bit broader than that. The FDA has approved mifepristone, which is the abortion drug up to 7 weeks. I mean, whether or not you believe that 7 weeks is acceptable or not is, I think, irrelevant. There are a lot of people out there who believe that that's taking a human life. And as pointed out by the Catholic Conference, I mean, that is a deeply held religious belief among many folks. And I think this raises serious constitutional issues and goes well beyond what most of us truly believe I guess, would truly regard as contraceptive. So for that reason, I oppose this.
Okay, thank you, Senator Obenshane. Are there other motions or further discussion? Then open the roll. Motions to report and re-refer to finance.
Ayes 8, noes 6.
Okay. Congratulations, Senator. We're through now with, thank you.
Thank you.
Congratulations. With Senator Lucas is first, then Senator McPike, and then Senator Eben. And Senator Serville has to get out of here for a subcommittee this afternoon, so he wants, but Senator Lucas is first.
Thank you, Mr. Chairman. All of us are pretty much have our backs to the wall based on timing for other committee and assignments. But I have Senate Bill 623. And 623 is a collective bargaining for firefighters and emergency medical service providers. What the bill does is it authorizes firefighters and emergency medical service providers employed by a political subdivision of the Commonwealth to engage in collective bargaining through political or labor organizations or other designated representatives. The bill provides for the appointment of 3-member board of arbitration regarding any dispute arising between an employer and firefighters or emergency services. Under the bill, determinations may be such board of arbitrations are final and disputed issues are binding on the parties involved.
Okay.
That is total essence of the bill, Mr. Chairman.
You asked to go first because you've got witnesses.
That's right. I had a
623, there's a substitute for it.
Yes. I'd like to move the substitute, please.
Okay, got a motion and a second to adopt the substitute. All in favor, say aye.
Aye.
Okay, the substitute's properly before the committee. The patron has described the bill in brief without us having seen the substitute. Are there people that want to look this over or want to
If I could get
ask her
counsel
questions?
just to explain the language in the substitute. Okay. Yes.
Yes, Mr. Chair, Senator Lucas. The substitute makes various changes, including the creation of the Fire Service Cooperation Board in Section 40.157.7, the provision of procedures for the certification of an exclusive representative of an employment unit in 40.157.5, and a provision that the bill will not invalidate the existing selection or certification of an exclusive representative before July 1, 2024. Thank you.
Thank you. That's the essence of the bill, Mr. Chairman.
Okay, are there additional questions for the patron? Are there those in the audience who would like to speak in favor of the bill? I see a bunch of people standing up back there. I'd ask you to be brief. Just identify yourself and whether if you represent a group and a word or two maybe about the bill.
Sure. Mr. Chairman, members of the committee, John Wright on behalf of the 10,000 Virginia professional firefighters, and we support this legislation and thank Senator Lucas for championing this issue. There are numerous issues facing firefighters and the fire and EMS services across the Commonwealth that are affecting public safety. These include recruitment and retention challenges, unsafe staffing levels, increased call volumes and response times, occupational cancer, mental health issues, mandatory and forced overtime, firefighter injuries and fatalities, just to name a few. Yet, despite all of these issues, the overwhelming majority of firefighters and EMS employees do not have a seat at the table to help address these issues. SB 623, the Firefighter EMS Employer-Employee Cooperation Act, allows these brave men and women and their employers to work together to protect public safety, protect the health and safety of these first responders, and promotes cooperation between labor and management. I respectfully ask that you act favorably upon the bill. Thank you.
Mr. Chairman.
Okay, thank you, sir. Senator Stanley.
If I could ask the witness question. I'm trying to go through the substitute here, and I come from a personal position where my son is a certified paramedic, and certainly the hours are long, the stress is great, and the pay is terrible. If you were allowed to have collective bargaining, and let's say it was the general consensus that you weren't getting a fair shake with management as you described them, would this would this legislation give you the ability to strike?
No, sir.
Okay, so
strictly prohibited in Virginia.
Senator Stanley.
Thank you, Mr. Chairman. So if you were in a disagreement with the locality, that would not stop the emergency services at any given time, would it?
No, sir. That's correct. We would never walk away from protecting public safety.
Thank you.
And doing our
Thank you, Mr.
job.
Chairman.
Information, share it. Otherwise, just share your name and tell us
Yes,
who
Mr.
you
Chairman.
represent.
Members of the committee, Max Canono, President of Virginia Beach Professional Fire and EMS. When we look at collective bargaining for firefighters, there are plenty of models and precedent. Due to the health and safety implications for firefighters, the general public, and improvements that can result from collective bargaining, there are 35 states that mandate collective bargaining for firefighters, and that is more than any other group. Those states include Texas, Florida, Alaska, Oklahoma, Kentucky, Idaho, Wyoming, and South Dakota. The collective bargaining process, which mandates discussions, not outcomes, is good for communities as well as firefighters. Virginia would be in good company to move forward and do the same. Thank you.
Okay, thank you, sir. Next, please.
I'll shorten mine up. Kurt Dietrich, Virginia Professional Firefighters, District Vice President, representing the 10,000 firefighters in the VPFF. Passing something like this gives the subject matter experts, the people that respond to these calls every day, a real seat at the table and pathway to address the issues that we have in the communities with city and county leadership, and that'll bring us a sustainable and safer community. I'd like to point out that since the 1935 National Labor Relations Act, almost 3/4 of the private sector has the ability to organize and work under a collective bargaining agreement. In many of our communities, the plumbers, framers, electricians, bricklayers building these fire stations, and the engineers and workers building our fire trucks and assembling our turnout gear are legally allowed to unionize and work under agreements. Everyone that touches that fire truck or builds that fire station can have a contract, except for the vast majority of the firefighters and EMS workers here in Virginia. So we ask that you support SB 623. Thank you.
Good afternoon, Mr. Chairman, members of the committee, and thank you to the patron for bringing forward this bill. Robert Young, Local 2068, Fairfax County Professional Firefighters and Paramedics. I won't bear you with all the details I have written here. I'll just say, during a committee meeting of the Fairfax County Board of Supervisors, where they voted 9-1 to accept the contract that was provided by the firefighters in the county, some of the favorable comments that they said was, the point of collective bargaining is to get our employees at the table and to hear from them. Another one said, it is because they have some of the best ideas about how to improve things. The final one said, we have an agreement that will serve us all very, very well. We appreciate it, and we hope it is the will of this committee to pass this bill. Thank you.
Thank you, sir. Next.
Good afternoon. My name is Keith Andes. I'm president of Richmond Professional Firefighters, IAFF, Local 995. My local is finishing up the last remaining articles of our first collective bargaining contract here in Richmond. While we had moments of disagreement, the process was performed with dignity and respect. And I know the City of Richmond's representation would state the same. A new day is needed in giving voice to my fire service brothers and sisters. The opportunity to negotiate over health, safety issues, equipment, and benefits through collective bargaining gives them the future they so deserve. We ask all Senate, Commerce, and Labor Committee members to support Senate Bill 623 for all my firefighter heroes across the Commonwealth. Thank you.
You raise a good point. Let me ask you, localities have the ability right now to pass ordinances and allow collective bargaining for public employees. Isn't that correct?
Yes.
Okay. How many in the state have done that? For
8.
8? Okay.
Yes, sir.
Thank you.
Thank you.
Good afternoon, Mr. Chair. My name is James Incurvayo with the Chesterfield County Fire Department and Local 2803. We support this bill.
Mr. Chair, William Boger, Henrico County Professional Firefighters. We support the bill.
Thank you, sir. These guys get it.
Yes, they get it.
Yes, ma'am.
Mr. Chair, Tiffany Stewart, International Association of Firefighters, Local 539. We stand in support of this bill and thank the patron for carrying.
Thank you, ma'am.
Mr. Chair, Jason Parker, Virginia AFL-CIO. We support collective bargaining, which is a hallmark of a free society. Thank you.
Thank you, sir.
Mr. Chairman.
Okay. Senator McPike.
I have one question for council. It says we've excluded the previous agreements. As I read the definition of firefighter under lines 93 through 94, basically provides the collective bargaining provisions to basically everybody but the chief. Is that correct?
Mr. Chair, Senator McPike, that is my understanding, yes.
For the question, Mr. Chairman. So some of the existing collective bargaining agreements, as I understand it, have excluded provisions for people like an assistant chief or deputy chief that is dealing with financial, HR, and other matters that are under current law. Is that right?
You're asking her if she knows about what the local ordinances have done?
Yeah, Mr. Chairman, and in favor of the bill, my only concern is that you have folks, by that definition, being so tightened that you're excluding potentially and creating different collective bargaining agreement standards between jurisdictions, like the one Fairfax has adopted, Arlington, I think Alexandria, a couple others have adopted, and we create sort of two different standards where you have excluded. And so I would just like to speak if there's anything in this bill that helps prevent it, and again, I'm meaning no harm, I'm just making sure that we don't create two different tiers of collecting bargaining systems in Virginia.
Senator Lucas wants to respond to that.
Yes, I would like for Kurt Dietrich, and he is from the Portsmouth firefighters, to respond to that.
Yeah, the way that it works now is each locality's ordinance, how they adopt it, defines the scope of the bargaining unit. So the issue that we're running into is that one locality may have an assistant chief, another locality may have a deputy chief. The terminology is different across the state. Most localities are excluding the fire chief and then the deputy chiefs or assistant chiefs in that next level because they're the ones that, like you said, they're usually appointed by the city manager or county administrator. They work at their pleasure, and they would not be in a bargaining unit.
Thank you, Kurt.
Senator McPike.
Mr. Chairman, I'd like to see this move forward, but I would like to figure out maybe some better working definitions where essentially you have only one individual that is able to resolve based on contractual terms of a collective bargaining agreement, and that is solely the chief, versus those that would have responsibility to dig into the details.
Senator McPike, if this bill moves forward, it'll have to go to the Finance Committee, and that'll give you a few days to come up with those definitions.
We'll work it out in finance.
Okay, are there others who would like to speak in favor of the bill? Are there those who would like to offer a contrary point of view?
Mr. Chairman.
Senator McDougal.
If I understand right now, localities can do this. So under this statute, we're taking away the choice of localities and require them to agree to collective bargaining. Is that accurate?
I think that's accurate.
Chairman.
Senator Surville.
I guess, I don't know if it's a question, but to council maybe, but my understanding, it only requires localities to do it if their local firefighters want to do it. Is that right?
Yeah, Mr. Chair, members of the committee, that is correct. It would just authorize firefighters and emergency medical services providers to engage in collective bargaining if they so choose.
Right. Mr. Chairman.
Senator McDougal.
So again, though, it's not the elected officials in the locality making the decision. It's the people, it's the employees making the decision that they want collective bargaining. And so then the locality is forced into that, as opposed to right now, those same individuals who could vote for those people locally could go and make the argument for their community that that needs to happen for firefighters, EMS, law enforcement. And so now we're picking one particular group in a locality, taking that choice away from the local government.
I guess you could look at it that way, Senator McDougal, but that 140 people that are elected to represent the state of Virginia are deciding that an employee group can make a request for collective bargaining and the locality has to comply. But you can certainly look at it the way you've expressed. Senator Obenshain.
Mr. Chairman, I recognize that probably 70 of the 140 members who are voting on it are new, but I was here, I guess, a couple of years ago when we passed that legislation making it permissive, and I distinctly remember the heartfelt appeals for passage of this legislation and the assurances that were given that nobody's going to cram this down the throat of your community. If your community and your governing body doesn't want it, this isn't going to do anything about that, and we're not about to force this on your communities. It seems to me that with the impanelment of this new General Assembly, it is about to be crammed down the throats of communities across the Commonwealth of Virginia, whether they want it or not.
I guess you could look at it that way, Senator Obenshain.
Can I offer a point to that?
You want to respond to that?
I'd like to offer a point to that. That is true, Senator and Chair. It is up to the locality. There's local option. And even if this goes through, which we hope it does, other employee groups in the cities and counties would still have that ability to go through their elected body in their locality. But I can tell you from firsthand personal experience that when a group of employees in these cities and counties in Virginia bring this forward, they're met with intimidation, with bullying, with retaliation from their employer, who is a city manager or county administrator. So this is offering protection to those workers and employees, the firefighters and paramedics that do this job all across the state.
You think so? Yeah, mine too. If we're having a fist fight between a firefighter and a county administrator, the firefighter is going to win.
Can't lose with firefighters.
Yeah. I've been advised that we have somebody online that wants to speak to this bill, and if they will turn on their camera, they'll have a minute. If they identify yourself, any group that you're a part of, and anything new, I'd appreciate it.
Good afternoon. My name is Brian Lynch, President of the Arlington Professional Firefighters and Paramedics Association in Arlington, Virginia. I'd like to speak in favor of the bill. Last year, we reached an agreement with our county that created better incentives for firefighters to stay on the job. But more than that, we created a labor management process to make sure the department's stronger. Through regular collaboration, we have settled issues that could have become adversarial grievances. And with firefighters' expertise now at the table, we have begun to reform many of our department's practices in areas such as staffing. This was not the case before we had the rights that every Virginia firefighter deserves. If you believe in finding common ground to make communities safer, then I urge you to support this bill. Thank you for your time.
Okay. Thank you so much. And for the members, he was on camera, but I had to look over the clerk's shoulder to see his face. There was just a technical issue with us.
I can see him there, but I couldn't.
So, are there others in the audience who want to speak to this bill? If not, a motion to report is a motion to report and refer to finance. Okay. Are there additional motions or additional discussion? If not, open the roll.
Ayes 8, noes 6.
Ayes 8, noes 6. I'm seeing a pattern here. Okay. Senator Lucas, congratulations.
Thank you so much.
Okay, Senator McPike is next.
Thank you, Mr. Chairman. I have Senate Bill 241. This is a bill that this committee has seen, and I think just about everybody has voted on this body.
241?
241, Mr. Chairman. And this is a follow-up from a JLARC recommendation almost 3 or 4 years ago, and I've carried it multiple times. It provides for essentially, upon denial of a workman's comp claim, it requires that the notice of the appeal process be mailed out to that individual that had applied. And so right now what happens is they're provided with the information on how to go through the process of a claim. Included in that is the appeal process. However, sometimes it's often months and months and months before they get a denial letter. This simply sets out the exact language in which they can apply. We've heard and passed this bill multiple times through the Senate, died by one in the other chamber.
I understand all that, but aren't they people advised, isn't the claimant advised of their right to appeal at the time they receive something from the commission?
Mr. Chairman, only at the initial filing do they get the information packet. When they receive a denial, they do not receive any more information whatsoever about how to appeal that denial.
Is that workers' comp law? You're still here? He's gone? Okay. What sort of information does a claimant get when claim is denied?
Well, it depends on your definition of denied. So merely telling your boss, hey, I got hurt at work, and they say, well, we're not covering that, that's not the same thing as actually filing a claim with the commission, right? So filing a claim with the commission may trigger some sort of paperwork where the employer then has to file something and they're notified that they're denied. But without actually filing something with the commission or taking a proactive first step, there's really nothing generated automatically that tells them that they have these rights.
Okay. Are there additional questions from the committee? Are there people here to speak in favor of this bill?
Mr. Chairman.
Senator McDougall.
Then tell me on lines 13 through, I guess, 16, what is the trigger for the issuance of this notice? If an employee comes, Mr. Chairman, if an employee goes to an employer and says, I was hurt at the job site, and the employer goes, okay, what do you want me to do about it? Is that a denial? I mean, what's the... do they have to file something in writing? Is it verbal? What?
Mr. Chairman.
Senator McPike.
The provision of this chapter, there's already preceding sections of the chapter dealing with initial claims and how to do that. This is the next part of the chapter where they've been denied. And so this is a subsequent part of the chapter to follow up to say, okay, I've gone through the official, I've filed the official paperwork, now I've been denied, what do I do next? Right now the code is silent in terms of actual appeals notice that employer or the self-insured should be providing.
Okay, this is after the hearing examiner has heard the case, denied it. This requires the insurance company to send some notice of appeal rights to the claimant. Is that correct?
Kind of in between. So
Okay.
what he's saying is the claim is filed and employer has a deadline to file a response saying we're accepting or denying your claim, but it doesn't say anything further than that. It doesn't say you have the right to appeal, you have the right. So what happens is when someone's hurt at work, technically the employer is supposed to notify the commission even if the employee does not file a claim. And so the commission may have a file, but that means nothing. An employee can then file a claim, and the employer then has a duty to send a notice, yes, we'll accept it, or no, we're denying it, but it doesn't say anything further than that.
Okay. Are there those in the audience who would like to speak in favor of this bill? Are there those in the audience who are opposed to this bill?
Mr. Chairman, I just want to make sure I understand logistically.
Okay.
So
Senator McDougall.
Nobody has to, the employee does not have to file a claim for this notice to be required. Is that accurate?
And there are instances when an insurance company or employer may proactively actually send a denial letter even when a claim hasn't been filed.
Mr. Chairman, I guess the part that I'm getting a little hung up on is right there at the beginning of this. If we're saying with a denial letter or with a denial notice, this has to be sent, that gives me a greater comfort level. This just says that this doesn't bring that. That's where the stage is, and maybe there's other code sections that this is inserted in to make it there, but I can't read that from here, and I'm not as familiar with workers' comp.
And what line's that on?
14 and 15.
Shall include in its letter denying benefits. That is on 14 and 15. And notice the employee has the right to dispute the claim denied through the Virginia Workers' Compensation Commission.
So, Mr. Chairman, this is
Senator McDougall.
This is at the employer stage, not necessarily the insurer stage.
When the employer files their notice of an injury, it doesn't automatically trigger anything. So in some instances, an insurance company may send a letter saying, hey, we've received notice of this and your claim is denied, but that's not automatic. That's not the case now. The only time something is automatically generated is when a claim is actually filed by an injured worker. Then there's what's called a 20-day order, meaning the employer has to file a response within that time frame. That order, again, is very minimal, and a lot of people don't necessarily understand it, and people have come to me and said, my claim's been denied, I don't know what to do. So those who are lucky enough to at least contact me, I can tell them, okay, the denial doesn't mean your case is over. It just means that we have to now take the next steps and move forward.
Mr. Chairman.
Senator McDougall.
And again, this is not my area, but does that 20-day order, is that always required?
It should be. It doesn't always happen, to be candid, but it is part of the rules that they have to file something advising one way or the other. What you also see many times is they'll check a box that says they'll say it's denied, then they'll say under advisement or we're investigating. And so sometimes these things stall out, and a lot of claimants may not understand that they need to be proactive to move it forward.
And Mr. Chairman, we have also JLARC here as well, which did the study and pinpointed this is one of the biggest issues of the denial, really chain, I'll call it. And so they're also here as a reference for you if you need any further.
And Mr. Chairman, I've been told that the commissioner is online. Maybe they can.
Do we have a commissioner online?
No. information.
Let's hear from the pros and cons, and then we'll hear from J-Mark.
All right, Mr. Chairman, members of the committee, John Wright on behalf of the Virginia Professional Firefighters. We support the legislation Senator McPike has brought forward again this session. As he just stated, this is a recommendation from JLARC study of the 2019. It was a 2019 JLARC study of the entire workers' compensation code.
Dr. Emily Gann, Virginia Education Association. We support this bill.
Mr. Chairman, members of the Commission, Drew Dickinson with JLARC, led the study. So workers' comp, very complicated. The process, this would just make sure that, so there's a notice sent out when an employer receives a notice of injury. Should go to the workers' comp, who then sends out a notice. But as the Senator McPike said, it could be long after before the determination is made as to whether they're going to deny or agree to the claim. And so what this would do, which is already done by some localities, is to say, if you're going to deny, in that letter that you give to the employee, if you're going to deny the claim, you need to include a notice that they have the right to appeal. And so we brought this partly because did a survey of firefighters, and 49% didn't know that they could appeal their claim. So happy to answer any questions. I just wanted to clarify that process.
Second.
Okay, we've got a motion to report and a it's been properly seconded. Are there additional motions? Is there further discussion? Open the roll.
Ayes 13, no 0, 1 abstention.
Okay, ayes 13, no 0, 1 abstention. Senator McPike, your bill of report. Senator Abbott.
Thank you. Senate Bill 593.
You're next.
Yeah.
I'm sorry.
That's right. Senate Bill 593, Mr. Chairman.
Okay.
And I do have line amendments to offer, and so move. The line amendments basically change the original bill version, Mr. Chairman, to what is received as a compromise. Initially, the bill basically struck out the limitation of 52 weeks. What we've done is basically agreed amongst parties to 104 weeks, Mr. Chairman. What the finding was is essentially the 52 weeks is just not long enough to deal with the basic treatment and necessary under PTSD. And so working with the various companies.
Is it my understanding that with the amendments, you essentially have peace in the valley?
I'll let others affirm, but yes, Mr. Chairman, okay. And so move the amendments.
Okay, are the amendments in written form? Do we have them? Can we distribute them?
Mr. Chair, members of the committee, the line amendments strike the language unstrike the stricken language in line 75, and then replace the number 52 with the number 104.
So you are essentially going to 2 years for a maximum benefit of 2 years.
It basically goes from 1 year to 2 year, Mr. Chairman.
Okay. And the initial bill was to take it 4 years. Is that correct?
The initial bill basically removed the limitation of time.
Okay. But the compromise is to go to 2 years.
That's right.
Okay. Do you understand that amendment? Okay. All in favor of that amendment, say aye.
Aye.
Opposed? Okay. The bill's been amended. Okay, I think it's been described. Are there people that want to speak in favor of this bill? Please be brief.
Mr. Chairman, members of the committee, Jennifer Pike with Virginia Professional Firefighters. Firefighters, paramedics, and law enforcement officers bravely protect their communities every day, willing to sacrifice themselves to save others. Over the course of their career, they experience exposure to horrific events which often lead them to becoming ill or suffering from a mental health crisis. We know that their roles and responsibilities position public safety personnel in situations that increase levels of trauma. The men and women who serve our communities throughout the Commonwealth deserve the benefits outlined in this legislation before you today. Senate Bill 593 allows the necessary time of treatment for PTSD and anxiety and depressive disorders, which provide our firefighters, paramedics, and law enforcement officers with proper behavioral health treatment. We've worked with the stakeholders, are in agreement with the changes to this legislation. And Mr. Chairman, members of the committee, I hope it's the will of this committee to pass this very important legislation, which will make a significant impact on the future of the men and women in uniform. And I do want to clarify, the PTSD removes the 52-week limitation and adds 24 months, so it caps 24 months for the anxiety and depressive disorder.
Yeah, and Mr. Chairman, we'll need to do an amendment. I think that if this is going to finance, to make a correction to that.
Yeah, we will have to go to finance.
So we'll pick up the other edits that were agreed to, and my apologies to DLS. I think we missed one component in translation, but we'll get it right as it goes to finance, Mr. Chairman.
Okay, are there others who want to speak in favor of this bill? Are there those that have another view? So they're report and refer to finance. Motion made and seconded. Are there other motions, other further discussion? If not, open the roll.
Ayes 14, no zero.
Senator Reben, he's got a subcommittee starting in a few minutes. Yes. So if you have a bill we can take up quickly, Senator Survell. Yeah. Okay.
Should I do it from here, Mr. Chairman?
No, outside the door. Do it right there. Yeah. Just move along.
Great. One is Peace in the Valley, and the other one is one we heard last year. So Peace in the Valley is the Senate Bill 257. This has to do with lost reserves on dental insurance.
Okay, 257. I've heard from all the parties, and I think there is a Peace in the Valley. And that do you have amendments?
I don't think so.
The bill is adopted. Okay, do you want to describe briefly what the bill's all about?
Sure. The bill basically just requires dental insurance carriers to disclose their actual loss ratios annually in a report to the SCC. The Bureau of Insurance is going to post those loss ratio reports on their website, and then there's going to be a group of stakeholders that are going to convene with the work group of the Bureau of Insurance to see if there's any additional changes that are needed in fairness on dental carrier practices, and it'll provide more transparency on how dental insurance rates are set. That's basically what it does.
This is basically a collection of information and a report and a study bill.
Yeah, but it requires dental insurance companies to start posting their actual loss ratios annually, which they're not required to do right now, which provides more transparency to how they set their rates.
And the insurance companies are all right with that?
Yeah, they are.
Okay. Got a motion to report. Is there anybody in the audience who feels compelled to speak to this bill? Okay, motion to report's been seconded. Are there further motions? Is there further discussion? If not, open the roll.
Ayes 14, no zero.
Okay, Senator Surville, you've got another bill.
I have Senate Bill 86. And I'm sorry? Oh, I'm sorry, 507. 866 was the number last year for the same bill. Yeah, it's 507. This has to do with paid sick leave for grocery store and healthcare workers. Mr. Chairman, there's not Peace in the Valley on this one, but it's a bill we've heard 2 years in a row and passed 2 years in a row.
Let me ask you, isn't there a broader sick leave bill?
Not in our chamber. I believe there's one on the other side.
Okay. This is a bill we have heard before. If it's reported, it's going to have to go to finance because it's got a fiscal impact.
Yes, it does.
But we heard this bill last year.
You want me to explain it, or?
I think probably everybody remembers this bill, don't you?
These two guys on the right might not, but everybody else.
Okay,
probably.
if you want to explain it in 2 minutes.
Yeah, well, the quick version is it requires about 1 hour of sick leave for every 30 hours worked per month for most healthcare workers and grocery store workers in grocery stores that employ more than 25 employees. The reason for that is, or the reason it came to my attention, and I put this in 2 years ago, is because these folks were out on the front lines during the pandemic, didn't really have a choice as to whether or not they wanted to work or whether they would be exposed to illness. You know, the healthcare workers, the people that were selling food in grocery stores. So that's the shortest version I can give, Mr. Chairman. I can get into all the people that died and everything else during the pandemic, but that was the policy. And it passed, I think, on a party line both years.
Report and refer to finance.
Okay, we've got a motion to report and re-refer to finance. Is there a second?
I'll second it.
Okay, got a motion and a second to report and re-refer to finance. Are there other motions? Is there further discussion? If not, open the roll.
Sorry.
Ayes 8, no 6.
Okay, thank you, Senator Servell. Senator Eben, you indulged your seatmate there. You've got Senate Bill 382.
Senate Bill 382 has some line amendments that were suggested by the Virginia Employment Commission Deputy Commissioner, and I can explain the bill whether amendments are being passed out. This bill is a recommendation.
The amendments have been distributed. Let's get them properly before us. Okay, got a motion and a second on these line amendments. They're on the first pages. There's 7 of them. First front and back page of this handout. All in favor, say aye.
Aye.
Opposed, like sign. Okay, the bill as amended is properly before us.
Okay, this bill was recommended by the Commission on Unemployment Compensation. As amended, the bill would establish a 5-year statute of limitations on the collection of non-fraudulent overpayments. This bill would also require the VEC to discontinue collection on overpayments when a recipient dies or declares bankruptcy. There are currently no mandatory limits on the collection of unemployment overpayments in Virginia. Under current law, the VEC may discharge overpayments whether they're non-fraudulent or fraudulent after 7 years with good cause, which is undefined in the code. Under current law, VEC is not required to discharge overpayments in the event of a bankruptcy or death. While the original bill proposed a statute of limitations of 3 years, the VE stated that this could lead to unintended consequences like higher monthly payments and potentially more civil actions against claimants. So I accepted the agency's recommendation of setting a limit at 5 years, which the VEC stated would eliminate or at least considerably reduce these impacts. Basically, what we're doing is saying if you're overpaid on your unemployment claim, that the VEC has 5 years to come back to you and collect those funds. And you may ask, what does this do for the VEC? First, it relieves VEC of a massive administrative burden. As the U.S. Department of Labor states, notes, they say that states have accumulated very large amounts of overpayments on their books, even though it may be impossible to recover much of the total. This has created an administrative burden to maintain these records and distorted the amount of overpayments that are shown as collectible at both the state and national levels. Thus, the U.S. Department of Labor already requires states to remove overpayments from their reports after 2 years unless recovery is in progress. Likewise, 38 states allow or require non-fraudulent overpayments to be written off after a specified period of time. Most states' statute of limitations are set at 5 years or fewer, as ours would be if this bill passes. Second, this will allow VEC to improve its recovery rate. Under federal law, VEC is required to recover 68% of overpayments that have not been waived or discharged, but in the past 2 years, VEC's recovery rate has not reached even 5%. Third, this will encourage VEC to engage in a broader range of recovery efforts in a timely manner. And their current primary method of overpayment recovery is through the offset of future unemployment benefits. So claimants who receive overpayments innocently, meaning without fraud, often do not have the ability to repay without the overpayment. The VEC would therefore rely on taking all or half of the claimant's future unemployment benefits to which they're entitled. And that's the bill that's before us. I worked on this with the Poverty Law Center and appreciate the Virginia Employment Commission's input.
Mr. Chairman,
Senator Obenshain.
unless there's opposition, I think this is an outstanding bill, and I would move that it be reported and re-referred if it needs to be.
Does this bill this bill does need to be re-referred to Senate Finance. So the motion is to report and re-refer to Finance. Are there people here who would like to speak in opposition to the bill? Are there other motions? Senator Rouse, I apologize.
Just a quick question for the patron. Can you just help me understand if there's a miscalculation in how much an unemployment, receiver would receive, not on the, receiver's part, but on the part where they just made a miscalculation. Maybe they was receiving an extra $10 or $50. That cost would be would that fall under this bill right here?
Any overpayments that the VEC determines after they've made the payment, yes.
And if they would have 5 years to reconsider if they made an overpayment of that?
That's correct, which is a reduction in their current practice.
All right, thank you.
Okay, thank you. Are there additional questions for Senator Eben? If not, we have a motion on the floor. If there are there additional motions or further discussion? If not, please open the roll.
OBM, yes.
So, is that what you want to do?
Surville?
Yes.
Okay, I don't have your.
No.
Figures you just use it with a pencil.
Thank you, Mr. Chairman. Members.
Thank you, Senator Eben. Okay, now we have a letter or bills from Senator Bagby and Senator DeSteff and Senator Reeves. They're both still down there. Okay, Senator Bagby.
Thank you. I believe you want me to go to.
Yeah.
Was it 536 you want me to go to?
I want you to do what you want to do.
Okay. All right. This bill would.
That's right. He is bigger
This
than
bill
me.
would make permanent some of the key provisions. This bill would make permanent some of the key provisions which we authorized the Virginia Employment Commission to grant waivers for the overpayment of unemployment benefits. And there are two authorized waivers. One with fault in the overpayment, and then the second when it could not be repaid without foregoing basic necessities. And I would move the substitute.
Second. Okay, got a motion and a second to adopt the substitute. All in favor, say aye. Aye. Okay, the substitute is properly before us.
Thank you.
I wonder if there's any part of this bill that's inconsistent with the bill we just passed from Senator Eben, 382.
Just call me when you're out.
Okay.
I would have to rely on counsel. I would suspect the same person wrote it. Hold on.
Well, Sarah, what's the word?
Mr. Chair, members of the committee, my understanding is that they're not inconsistent, but I will give it another look and make sure.
Well, the concern I had was there was a waiver after 3 years, I think in 382. Or is it in this bill? Changed it to 5 years?
Mr. Chair, so the bill you just passed, correct, did have a waiver after 5 years. Commission shall waive after 5 years. This is a hardship waiver, which would apply much sooner than that.
Okay. Got both. Okay. And this is also a bill that'll have to go to finance if we decide to report it. And you you've got anxious, you got something to say?
Hi there, Flannery O'Rourke, Virginia Poverty Law Center. I worked with Senator Bagby on this bill, and I just want to say that there's a distinction between a waiver, which is this bill, and the prior bill, which is a write-off. So this is only for persons who are without fault and for whom it would be against equity and good conscience to recover the overpayment. That's a fancy way of saying they cannot afford to repay it. So this is provided at the start, the moment that the overpayment is created. They have 30 days to complete a waiver application. So it is distinct from the other bill, but not in conflict with it. Thank you.
Are there those that would like to speak in favor of the bill? Are there those who have who don't like the bill and want to talk about it with Senator Bagby in a dark room?
Mr. Chair.
Senator Obenshain.
But, and maybe I'm reading this too fast on the fly, but doesn't this, I mean, in addition to the repayment portion, I mean, doesn't it deal with continuation of payments and in cases where there is some determination or indication that the continuing payments are erroneously being made? Doesn't it limit VEC's ability to terminate those payments? And maybe VEC can answer that question.
Mr. Chairman, Jeff Ryan with the Virginia Employment Commission. There is a provision in the bill about continuation of payments that mirrors a requirement in federal law that essentially we have to issue somebody a actual decision in order to stop payments beyond 21 days. It's kind of a presumption of continued eligibility until we actually issue a formal appealable decision. So that language is new, but it's consistent with what's required under federal law.
Further question, Mr. Chairman. So is that your current practice?
Yes, sir.
Okay. So this doesn't change your current practice, or at least that portion of the bill does not?
No, sir, it does not.
Thank you.
Okay, are there additional questions? Are there other people who would like to speak to the bill? We've had a motion to report, I think, and we got one. Did you want to speak? Speak now or forever hold your peace. You might speak too much, we'll kill it.
Mr. Chairman, members of the committee, my name is Pat Levy-Lavelle with Legal Aid Justice Center. We support this bill. It helps Virginia join 41 other states, including multiple states across the South that have overpayment waiver provisions. Thank you.
Okay, thank you. We've had a motion to report and refer to finance. Are there additional motions? Is there further discussion? Please open the roll.
Oh, I got.
Ayes 14, no 0.
Okay, the bill reports. Senator Bagby, you've got another one.
Thank you, Mr. Chair. Mr. Chair, this one is going to be easier. This bill amends the Virginia Unemployment Compensation Act, and it disputes disqualification to provide that a lockout by an employer shall not constitute a labor dispute, and provides that lockout employees who are otherwise eligible shall receive those benefits. And it's
so this will allow employees who are locked out through action of their employer to receive unemployment benefits.
Correct.
Okay. Straight policy decision. Are there people that would like to speak in favor of this legislation?
Mr. Chairman,
Senator McDougall.
How do we have a lockout in Virginia if we're still right to work now?
I didn't hear him.
I just don't, my question is, if Virginia is still right to work, so with private employers at least, they're not unionized, how can there be a lockout situation?
I think we have some examples.
When the workplace is organized, I mean, couldn't there still be a lockout?
I think we have some examples if you let them speak.
Okay. No. People that would like to speak to this, I'd ask you to be brief. Identify yourself and your organization. If you can respond to Senator McDougall's question, that's great.
Thank you, Chairman and Senators. My name is Neil Graham with the International Brotherhood of Electrical Workers.
I have the distinct pleasure of representing the employees of Local 1434, among many others throughout the state, who are unionized under collective bargaining. In 2021, DuPont locked out those employees, and they were not entitled to unemployment benefits under Virginia state law. Many of them during the holidays suffered greatly. We feel like this is sensible legislation that the majority of states provide locked out employees access to unemployment benefits. We feel like that the legislature should approve this to ensure that locked out employees have some minimum level of monetary subsistence.
Do you know of a lockout that's occurred in Virginia in response to Senator McDougal's question?
Say that again, please.
Do you know of a lockout that's occurred in Virginia?
Yes, in 2021, DuPont, right here in Richmond, DuPont Spruance, locked out 100 plus employees represented by IBEW Local 1434. 74-day lockout.
Okay, thank you, sir.
Mm-hmm.
Okay, next.
Jason Parker, Virginia State Building and Construction Trades Council and Virginia AFL-CIO. I would like to answer the senator's question. All right to work does is prohibit a security clause between a private union and a private business partner. And so it would have no effect on any, but when you go into collective bargaining, that doesn't have a single bit of effect. Everybody, for some reason, smashes together like right to work with, just cause employee or at-will employee that has nothing to do with each other. That's all it prevents. And we support this legislation. What the problem is, these things, these lockouts and strikes, which is kind of the company's version of a strike, is it creates a lot of problems with the economy, and we probably should not promote as much as we can. And there's always going to be impasse, both either a strike or a lockout. And under the circumstances of good faith bargaining, if you're going to go in there and you're going to first right out of the box just lock out the employees to create economic harm as some kind of chip, it disrupts the economy of Virginia, and it's not good for the workers. It's not good for anybody involved. So we support this legislation. It's about time. Thank you.
Okay, thank you, sir. Next, please.
Mr. Chairman, committee members, my name is Jess Robertson, Sr. I'm right now currently the business manager for Local 1434. At the time of this lockout in 2021, I was just an employee. It was great financial problems with me and my family during this time. We were locked out and we was not able to get unemployment benefits, and I ended up going back and finding a construction job, and I was lucky compared to some of the guys I work with who could not do that and was able to get by during that time. But it was a very difficult time for me and my family, and I support this bill.
Thank you, sir. Next, please.
How you doing? My name is Brian Taylor. I'm the current president of the local IBEW 1434. I was directly impacted by DuPont's decision to lock out 96 employees back in October. It was extremely difficult to maintain household and living expenses with a wife, a toddler, and his school-aged children. As a provider, it left me scrambling to find employment. Luckily, I was able to find employment within 30 days, but a lot of my brothers and sisters weren't. So unemployment claims were denied because we want a lockout that DuPont did that we had no choice in the matter of. So thank you, and we support this bill.
Thank you, sir. Okay. Yes, ma'am.
Flannery O'Rourke, Virginia Poverty Law Center. We strongly support this bill. 30 other states already have this legislation, including both right-to-work and non-right-to-work states. Thank you.
Okay, thank you, ma'am.
Good afternoon. My name is Charles Kelly, business manager of IBEW Local 666. Many of the members of Local 1434 were members of our local previously in construction before they moved into the plan. I'm here just in support of the legislation.
Okay, thank you, sir. Are there people that have another view that are opposed to this legislation? Okay, if we're going to report the bill, it has to be reported and re-referred to finance. So the motion's been made and seconded. Are there additional motions? Is there further discussion? If not, please open the roll.
Ayes 9, noes 5.
Okay, Mr. Senator, staff, you're the next one on the list. And then Senator Reeves will back cleanup for us.
Okay.
The last two bills.
Those are the last two bills. We'll be through with the docket.
Yes.
We got enough.
All right, Mr. Chair, members of the committee, Senate Bill 655 is what we'll call the VEC Appeals Modernization and Cleanup Bill. So the Virginia VEC, in this bill, we specify that any determination made by VEC Commission in regards to any amount required to be deducted and withheld from unemployment compensation for purpose of child support obligations is final. The bill contains a number of technical amendments related to the Commission's appeals process, number of cleanup pieces of the code, and an elimination of a section of the code that's no longer used. With that, I have some folks from VEC who would like to chime in on this as well. Oh, sorry, Mr. Chairman. I have to move the amendments, which give us peace in the valley between a couple of the groups. Nope, I believe, Mr. Chairman, everybody's happy right now.
All in favor of adopting the amendment, say aye. Aye. Okay, any opposed? Okay, the bill as amended is before us. Are you ready for questions?
Mr. Chairman, I'm ready for questions, and we've got folks in support as well.
Anybody got questions for Senator? Okay, you got people here in favor of the bill?
Chair, I
Might as well
do. Bill, line 52, such determination issued under subsection B shall be final. I mean, would that be even clearly erroneous determinations?
Mr. Chairman, Senator Obenshain, I'm going to phone a friend on that one.
Mr. Chairman, Jeff Ryan with the Virginia Employment Commission. Senator Obenshain, that particular line applies to child support orders. So it just clarifies that as a matter of our practice, we withhold child support payments from unemployment insurance payments, from non-custodial payments. We remit those to the Department of Social Services, and they give those to the custodial payments. It just clarifies that people cannot appeal their child support order with the VEC.
So, Mr. Ryan, even if you get it wrong, it's final.
Yes, sir. We get it from the Department of Social Services. If they want to take it up, they can take it up with DSS, or they can take it up with the court, which orders their child supports to begin with.
Senator Obenshain.
I mean, doesn't that, and I'm all for collecting child support, but doesn't that work both ways? I mean, if it's $500 a month and there's a determination that it's $50, does that become final?
So, Mr. Chairman, Senator Obenshain, we cross-check daily with the Department of Social Services, so if there's any change to a child support order, we adjust as payments are made.
Even, Mr. Chairman, even if you make a mistake, it's final, or you don't make mistakes?
As far as the child support order goes, we get the amounts from the Department of Social Services. We do not calculate child support.
You input it?
It's a digital interface with the Department of Social Services.
Yikes.
It's not something we manually calculate.
Yikes.
Got to take that up with the Department of Social Services.
You're welcome.
I am for Flannery Rock, Virginia Poverty Law Center. So thank you to the Senator and to the VEC for bringing this bill. We're grateful. It clears up an existing ambiguity in 60.2-619D, where it wasn't clear what time period applied for appealing a determination. And now it clarifies it's either one or the other of the two options. So thank you.
Mr. Chairman, we may want to get a picture because I think this is the first time I've ever had the Virginia Poverty Law Center support any bill I've ever done.
No. Virginia Poverty Law Center. He's going soft on you, boys. He's gone soft. Okay. We got 22 members coming up.
Prepare to be boarded.
Okay. Do we have a motion to report? And we had a second. Are there additional motions? Is there anybody in opposition to the bill? Okay. Open the roll.
Mr. Chairman, members of the committee, thank you.
Ayes 14, no zero.
Ayes 14, no zero. Congratulations, Senator Steph. Senator Reeves, finish this up in style.
Thank you, Mr. Chairman. I have an amendment if staff could read the amendment.
Mr. Chair, Senator Reeves, on line 15, after make, insert available to the consumer the option of completing. So that sentence would read, any financial institution that initiates an electronic fund transfer related to the sale to a consumer of a security issued by such financial institution shall make available to the consumer the option of completing any payment of principal, interest, dividend, or other distribution related to the security to the consumer via an electronic fund transfer. So it makes it at the option of the consumer.
Thank you, Mr. Chairman. This is a pretty simple bill. And actually, how it came about was I was actually trying to put some money away for estimated quarterly taxes. When I made the deal with the bank for the 7-month CD, they zapped my account within a matter of hours. That CD matured after 7 months. I asked them to put the money back in the account, and I couldn't put it back in the account without them sending me a check for a large amount of money, 6 figures, in the U.S. mail, which would take 10 to 12 days, even though I had estimated quarterlies due. I asked them why they couldn't put it back into my account, and the only way they could do it is if I opened up another account with the bank, because they couldn't put it back in the account that I had. So I've worked with Mr. Bruning on trying to get somewhat of an availability to make sure that banks, if they're going to zap something out of your account electronically, you can get it put back into that account electronically. It still leaves the mail option open for people who are dumb enough to have the U.S. mail deliver them a 6-figure check, but it'll also somewhat nudge these banks to the position where they have to make that flow of money go back.
Let me ask you, do the amendments take care of your problems?
Mr. Chairman, members of the committee, Matt Bruning with Virginia Bankers Association. We appreciate Senator Reeves being open to continue the discussion. I think there's still some concern about some of the lack of definition in the bill. Their securities is not defined in 6.2. That's under the Securities Act under 13.1. Electronic funds transfer is not defined in Virginia code. That is something that is governed at the federal level by the Electronic Funds Transfer Act and encompasses a whole lot of different transactions, including remote capture of checks, ATM transactions, and even if you call into your bank and make a transaction, that is under federal law and electronic funds transfer. So we're going to continue to work with the senator to make sure that maybe we address some of those, but we appreciate at least the amendment that was adopted in there to alleviate some of the concern, because there are people, whether it's wise or not, that do want different choices on how those distributions are made.
So what you're saying is at this point you're prepared for the bill to go forward, for you to continue to work with Senator Reeves toward finding peace in the valley?
That is correct.
Okay.
Move to report.
Okay, motion to report in a second. Is there anybody in the audience who's opposed to the bill? Okay. Is there anybody on the committee that's opposed to the bill? Is there anybody on the committee that's still awake? No. Okay. Unless there are additional motions, please open the roll.
Ayes 13, no zero, 1 abstention.
Okay, thank you, and that clears the docket. We left a lot of bills not on the docket for today, so we still have plenty of work to do. We only have a limited number of meetings left. We can meet a third time from now, but we'd have to waive readings, and we're going to try to avoid that to the extent possible. So 2 more meetings.
Finance meeting sub now?
It's finance.
Or sub?
Is that,
I have a little calendar.
I was just starting to kind of like
Did we move that? We never decided to move that.
We only have, go ahead and adjourn.
Oh, sorry.
we'll adjourn the meeting.